So we resume the debate on the Fourth Amendment to the Articles in second reading. And I had Deputy Renouf as next to speak. Deputy Renouf.
Yes, so regrettably I have one more point of clarification to seek from the Acting Attorney General, which is to ask a point that again arises out of questions that have been made, which is who are the people on different sides of the legal argument in a case that might be pursued in relation to this law. In other words, there's a third party, we know that. There's a third party who would be raising the legal issue. Who would be on the other side? It has been raised, for example, that it would be putting enormous stress on a person seeking assisted death to be on the other side of the equation, having to argue a case or have representatives argue the case. And I wonder if the Acting Attorney General could clarify who the two sides are in the argument.
Mr. Attorney Designate.
Yes, I'm entirely confident that it would not be the person requesting the assisted death, because the appeal is not against any decision that they have made. The appeal is against a decision made by a medical practitioner. The medical practitioner it will be working for the Assisted Dying Service if the Minister succeeds in establishing that organisation. Article 77 of the draft law says this: the provider of the service, the Assisted Dying Service, must be Health and Care Jersey acting for the Minister. So my firm view is the respondent to a third-party appeal would be the Minister for Health.
Can I make a speech as well?
Can I ask?
Deputy Gardner.
So a further point of clarification followed the answer from the Attorney General. There is a requirement for two medical professionals to make a decision. Would both of them will be answerable to appeal?
No, it's not they personally who would be attending the appeal. It's their decisions or their decision-making that is the subject of the appeal. Those decisions are made effectively on behalf of the Minister for Health. And so the respondent would be the Minister for Health.
And because follow-up question, and thank you, it's helpful. A follow-up question, because there are two medical professionals submitted their opinion and decision was made based on the two medical professionals' opinion, what court would require and where the further evidence court will receive to make a decision?
Mr. Attorney.
Well, that's not an easy question to answer because it would turn on a case-by-case basis. But if there are two decisions, for example, that a person meets the health criteria and it is suggested that both of those decisions are irrational, then the court, in the first instance, would no doubt wish to see those opinions and understand why those practitioners had reached the conclusions they had.
Unless there are any other questions, I call upon Deputy Renouf to speak.
Yes, I will try and be as brief as I can. I must say I've changed my view in the course of this debate. I had been minded to support this amendment because I feared the consequences of the issues of family rivalries and so on being opened up through the courts, and that felt difficult to justify. However, the reassurances that I have gained are that, first of all, the grounds for appeal are so very limited and are limited to procedural and legal matters, not to questions of opinion. I felt further reassured that the courts would be able to establish frivolous claims very quickly. And I feel that in those situations that the added safeguard that is put in, the reassurance, if you like, that there is an appeal process, should there be a rogue, essentially what we're really talking about is either a rogue or criminally incompetent actor in this process, that it is worth having a safeguard against that kind of situation, given that the risks that accompany it seem to me, on the reflections that have been gathered from various clarifications and speeches, feels to me that those risks are very, very small indeed. I do feel we're perhaps slightly dancing on a pinhead here. It's a situation where we're very, very unlikely to see this enacted, certainly according to previous, to what's been said. But since we are being called upon to make a choice, I think I will err on the side of rejecting the amendment.
Does anyone other member wish to speak on the fourth amendment? Deputy Miller.
Thank you, sir. So again, I hadn't intended to speak a great deal on this part of the debate, but I feel this morning we have again gone down. We have gone down quite a number of rabbit holes on this. I do intend to reject this amendment, and there's a number of reasons. Firstly, if I can go down the rabbit holes, we've talked about all sorts of things. Firstly, the court handling this. I have complete faith that our courts will be able to handle any appeal in a timely way, and they will sit whenever they have to sit to deal with these, that they're dealt with quickly as the parties and the lawyers can get the papers together. I don't believe the court process is something we should be concerning ourselves with. The subject of vexatious litigants. Vexatious litigants are normally people who bring repeated cases to court which are capricious or outright unreasonable, which are just meant to be annoying at times. In this context, a vexatious litigant would have to be a family member who is so despising either of the person who is seeking the assisted death or their own family that they want that person to continue suffering, the suffering that person continues to be unbearable, if you will. You are saying, no, I want my mum to continue and die in pain. That's a very difficult argument to... The court will see through that very quickly, I think, and I think we would all recognise where someone is just being really, really unpleasant. So I again, have confidence in the court to deal with that. We have to remember as well that we already have a proposition lodged to amend this law, to extend it, and we have to be careful that everything we do has to be accommodating of future changes to the law. It will change very quickly, possibly not as quickly as Deputy Southern might like, but it will change, and we have to processes that will accommodate those changes. And lastly, well, not quite lastly, we're again using human rights law to address a problem or a proposition that it was never designed to address. The European Convention on Human Rights was not written to enable people to seek assisted death. Assisted death was in nobody's mind when they wrote that law, and I doubt it was in anybody's mind when this Assembly introduced our own human rights law. And we also have to remember, we've talked a great deal this morning about the human right to privacy, because most of us, I think, to be fair, are coming at this from the perspective of what do I want for me, and we're coming with our own baggage, most of which I've heard has been about parents and older relatives dying. So we are coming at it from a very, very personal view of our own experience, but most of the things that I've read or seen about how assisted dying works in other jurisdictions is families being cut out of the equation, where families are called to say, your mother has opted for assisted dying and she passed this morning. And everybody who's promoting that right to privacy today, a great number of people in this Assembly have children who are or are approaching adulthood. How do you feel when you have a call from the hospital saying your child died this morning having taken an assisted death and you knew nothing about it? How does that feel? So we've got to remember all of these things. We've got to remember, because there is also, eating my own words, there is also a human right to respect for family life. The right to family life and the right to privacy, those are two balancing and possibly in this context completely opposing rights. So I won't be supporting the amendment because I do think we should retain an appeal from it. Thank you, sir.
Thank you, Deputy. Does any other member wish to speak on the fourth amendment? If no other member wishes to speak, then I call upon Deputy Doublé as chair of the review panel to reply.
Thank you, sir. I'm trying to organise my notes from before lunch, which makes slightly less sense to me than when I wrote them before the lunch break. This has been a really interesting debate, actually, and again, another one of those ethical points that is, I think Deputy Reniff called it dancing on a pinhead. It is a little bit like that. This is a further refinement, isn't it, of the safeguards. Some of the arguments have focused on the actual court processes and how the court processes might not actually result in any kind of successful appeals. And this brings to mind the actual harm that might be caused that we wouldn't know about, actually. And I mentioned this in my opening speech, is that, yes, you might not get actual vexatious litigants actually bringing a case forward in this respect, but what you're more likely to get, and the evidence around coercion is very clear, you're more likely to get people quietly using this as a tool to coerce somebody out of having an assisted death. And the fact that this facility could be hanging over that person who wants to make a conscious decision for themselves could be used as a tool, and we will never know in those cases if that happens, because those people are inherently people who, if they're victims of coercion, actually can't speak up about that, and if they're people who would be using the assisted dying service, they would no longer be alive to tell anybody about it. So that is my main worry with this, is that people who actually are suffering unbearably and wish to access the assisted dying service, that they would be coerced out of doing so. And this was a point that was raised by our advisors, that this could be used as a tool for coercion. And I thank all members that have spoken, and it's been really interesting to hear people's reasonings and to hear why people may have changed their mind during the course of the debate. And it's clear that all members are thinking really carefully about this, and that's very much appreciated. Some of the questions to the Acting Attorney General were also really helpful, and I think he mentioned that there are other avenues for people to make complaints or to raise concerns, one of those being the police. There is also the Assisted Dying Assurance and Delivery Committee, and there are also numerous points. So, for example, if you look at some of our recommendations and indeed our amendments, and much of them focus on coercion and on the detection of coercion, and would necessitate the practitioners involved in delivering this service having that contact with family members and being there to actually ask and answer questions. There would be lots and lots of stages where concerns could be raised. There would not be a need to go to the court to raise those questions and concerns. They could be very adequately covered by the mechanisms that are in place and by the professionals operating the service. And Deputy Tadjer put it really well. And he said, like, we've got a problem if it's not picked up already. And I think that's a really fundamental point, isn't it? That I have confidence actually in the draft legislation, and particularly as amended by the panel's other amendments, that all of the steps and the processes and safeguards are there, that we are not going to need these third-party appeals. And I think even some members who have said that they are going to vote to keep the third-party appeals have made the point that, well, it probably won't be used, will it? So again, that takes me back to my point about, well, if this facility isn't actually going to be used in the court, why leave it there as a tool to be used by abusers to coerce family members? Is there...
Sorry, I'm going to ask a question at the end of the speech.
Right. And my vice chair also spoke, and when we were talking about this in our panel meetings, I found Deputy Catherine Curtis, her reasoning quite persuasive about the person who is actually accessing the assisted dying service has to be of sound mind and has to have capacity, and that actually taking a third-party appeal process, for me, that is impacting on the dignity of that person. And when we were reviewing this legislation as a panel, we had two kind of core values that we agreed at the very beginning, that we would be very strong on the safeguards and scrutinising the legislation around the safeguards, and that we would also have patient dignity in mind. And for me, this part of the legislation, it doesn't actually add any safeguards. In fact, it creates risks around safeguarding for me, and it also impacts on patient dignity, because if you're somebody, and I think it might have been Deputy Tajo or another speaker that highlighted to us that, okay, even if it is only a couple of days, even if the court does act really quickly, if you're somebody who is unbearably suffering and ultimately going to die soon, I'm sorry, but a day or two, I think that's too long to have your agency taken away from you in this aspect. I also have some problems with the actual wording of the grounds. And I looked at the legal definition of the word irrational, and it's defined as a decision that is so illogical, perverse, or absurd that no reasonable person or authority could have made it. It signifies a lack of reason, sound judgment, or justification in fact or evidence. And again, we've got a big problem if there are any decisions being made in this assisted dying service. And so all of the evidence that my panel have reviewed and that we have put in the report that I know very well at this point leads me to feel very certain that we just don't need this process, that there are not going to be absurd, illogical or perverse decisions being made. And I think members who are generally in favour of an assisted dying service that has very clear and protective safeguards, this is a potential safeguard that is ambiguous and unclear and carries risk to the patient. And if you're in favour of an assisted dying service that has autonomy and dignity of the individual, of that patient at its heart, then I strongly urge members to support this amendment.
Deputy Dubé, do you agree to take a clarification question from Deputy Scott?
If I listen to the question, sir, am I compelled to answer it?
I think you can decline once you've heard the question.
Yes, I will then.
Thank you, sir. I just wondered if the Deputy could just go through this point about precisely how this, what it has been put in as a safeguarding measure, how this can be used to coerce somebody who has agreed to an assisted death to withdraw from that process when I just couldn't quite join that up. So if she could perhaps explain that reasoning. Thank you.
Sure, I'm happy to answer that, sir. And I think what the panel has learnt about coercive control in the course of this review has been really interesting, and I urge members to look at those parts of our review, because we have got amendments which, and we're very grateful, have been accepted by the Minister and we hope will be approved by the Assembly. But we learnt an awful amount about coercive control and how it can operate in this, how it could operate in the assisted dying service. And it is very perhaps not likely, but it is very, it could be used as a threat to somebody. Now, coercive control in abusive situations, and this is not just necessarily a romantic partner, but any kind of domestic abuse situations, which we know can be quite common in Jersey. For any reason, if somebody is being coerced out of their decision, this could be used as a tool to dissuade them from making that autonomous decision. I don't really have anything else to add. It's in members' hands to decide on how they want to vote now.
Thank you, Deputy. I think I heard the appel was called for. If all members have had the chance to return to their seats, I ask the greffier to open the voting. If all members have now cast their votes, I ask the greffier to close the voting. And I can announce that the amendment has been rejected. 13 votes pour, 33 votes contre, and no abstentions.
Can we have the 13, please, sir?
Those voting for the connotabs of St Brelard, St Mary, Deputies Southern, Labby, Doublé, Rob Ward, Mezek, Coles, Catherine Curtis, Feltham, Barbara Ward, and Stevenson, and online Deputy Alves.
Very well. We move on to debate 9 in the running order, which relates to the Fifth Amendment, which has been lodged by the chair of the Assisted Dying Review Panel. And I ask the greffier to read the Fifth Amendment.
Article 45. 1. In Article 45, for the heading, substitute 45, offence to coerce or maliciously induce decision to have assisted death. 2. In Article 45.1, for dishonestly, substitute maliciously. 3. In Article 45.1c, for withdraw, substitute not withdraw. New Article 46, after Article 45, insert 46, offence to coerce decision to not have assisted death. 1. A person commits an offence if they coerce another person, A, not to request assisted dying, B, to decide, 1, not to end their life by assisted dying, or 2, not to request assisted dying, including not to request to proceed to the next step of the assisted dying process, or C, to withdraw their request for assisted dying. 2, the person is liable to a fine. 2, renumber the subsequent articles and cross-references accordingly.
Deputy Doublé, would you like to propose the Fifth Amendment?
Yes, thank you, sir. This is 2 amendments in one, really. So when we were reviewing the legislation, we noticed that an offence has been created. 2 offences, actually. Either coercing somebody into having an assisted death, and another offence of coercing somebody out of accessing the assisted dying service. And as the panel were reviewing the draft legislation, we noticed that actually the offences were the same, the penalties were the same for both of those offences. So the maximum penalty for coercing somebody into having an assisted death, which obviously would be quite an extreme thing to do, the penalty of up to 14 years in prison. The panel felt that that was reasonable and proportionate, but then when we looked at the offence of coercing somebody out of an assisted death, the penalty was also maximum 14 years in prison, and we felt that actually there should be a more minor penalty for reasons relating to coercion, actually, and to allowing doctors and family members to actually have those kind of measured conversations with the patient about whether they want to access it. So what we didn't want was a doctor or a family member to be scared of saying to that person, are you sure that you want to access the assisted dying? And maybe we could do X, Y, Z, or you could access this medication, and having those really thorough and in-depth conversations. We didn't want people to be worried about being imprisoned for 14 years. We want to allow that space and the ability for people to question and test their thinking on it, and for their family members to do the same. So we separated those out, and we have asked for the penalty to be limited to a fine if there is found to be coercing somebody out of accessing assisted dying. And we also changed some of the wording. So the word dishonestly induce was used. And this, and again, was one that we had quite lengthy discussions about, and Deputy Balash and I had some really interesting discussions about legal wordings and the kind of legal definitions of words versus the actual definitions of them. And we settled on replacing the word dishonestly with maliciously, because we felt that was clearer than using the word dishonestly, and it implied that kind of that malice and that malicious intent behind the act that would make it clearer for the courts to make a decision. That is the rationale behind the amendments, sir, and I'm happy to hear members' thoughts on it.
Thank you, Deputy. Is the Fifth Amendment seconded?
Yes, sir.
Thank you. Does any member wish to speak on the Fifth Amendment? Deputy Morrell.
So rather than speak, I was wondering if I could ask the Attorney General a question, please, sir.
Yes.
And I was wondering if the Attorney General would be able to explain to us the difference between dishonestly and maliciously in this context. So.
Attorney.
Well, malice has a meaning in law. Dishonesty is said by lawyers to be a common English word with a common meaning. Malice in law means the doing of a wrongful act, willfully and intentionally, without just cause or excuse. Dishonesty is a word we all know. It means acting in a way that is not honest. That's the difference.
Thank you. Does any member wish to... Sorry. I saw the Minister's light first, so Minister, would you like to go first?
Very quickly, sir, I'd just like to say that the panel's amendment draws a helpful distinction between pressurising a person to have an assisted death and pressurising them not to. And it's an important distinction that wasn't mapped out in the original drafted law, so I hope members will see fit to support it, sir.
Thank you, Minister. Deputy Taddy.
So I think on balance, and I'll be supporting this, but I do so slightly reluctantly, in the sense that I think there is still quite a high bar that will have to be met for anybody on either side, I think, but if they're found to coerce one way or the other, and of course the penalty for coercing somebody who ultimately may not wish to end their own life is quite rightly has to be high and has to potentially engage a custodial sentence, because it's not necessarily exactly the same as, but it is getting into the area of effectively encouraging someone to end their life unlawfully. In fact, that's exactly what it is. But I don't think we should be sending the message out as an assembly that it is a small thing to coerce somebody the other way either. As we've said, in all of this, there is coercion possible on two sides. And in an ideal world, I wouldn't be removing the option of a custodial sentence from the court. I think that should have been left on the table, albeit for a much shorter sentence. As I said, the inclusion of malice in this rather than the ordinary English word of dishonesty, I think does set a high bar for that. So it means that in itself should have been sufficient to reassure family members, friends who want to have an open discussion one way or the other, that unless they're doing something, I think, intentionally and with nefarious motives, that they can do so without falling foul of coercing and falling foul of this law. So I just wanted to put that on record, that I'll be supporting the amendment today because it's better than what the law would be unamended, but I would have preferred a bit more latitude for the court, especially in a serious case where there's been coercion, to keep somebody alive against their will, who of course is suffering. So I think we need to start thinking about the fact that somebody's coercion could also cause serious bodily harm, in effect, in terms of the continued suffering from that harm, and that is no small thing. If it were done in a different context, a person may well be facing a custodial sentence, if all the circumstances allowed for it, sir.
Thank you, Deputy. Does any other member wish to speak on the Fifth Amendment? Deputy Balash.
So I take a different view from that of Deputy Tadier. I, at one stage, was minded to oppose this new Article 46 altogether, because it seems to me that it's the natural thing to do for a family member to seek to discourage a close relative from having an assisted death. And I did not want family members to be deterred from expressing their views firmly to a patient by the notion that they might be subject to criminal investigation for having sought to coerce the patient into not taking a decision for an assisted death. I'm still a little ambivalent about it. It is true that coerce is a strong word, but nonetheless, the risk of a family member being put in fear of a criminal investigation for doing, frankly, what comes naturally seems to me to be quite a strong argument against having this article at all. And I don't think that the law would lose very much if it were not to be an offence to coerce somebody into not having an assisted death. Perhaps I could request the chair of the panel to seek a separate vote on Articles 45 and 46, so that members who share my views might have the opportunity of voting against Article 46.
Thank you, Deputy. Deputy Morel.
So it's another question for the Attorney General, following directly from Deputy Balash's speech. And it is just to understand, in the Attorney General's reading of the proposed amendment, in that part which is about coercion out of assisted dying rather than into assisted dying, does the Attorney General see a route by which family members who are expressing their reservations and, perhaps are trying to talk somebody out of it, would he see there being a route to prosecution in those situations with the draft before him? Thank you, sir.
Jenny.
Well, I take the word coerce to imply or include an attempt to suborn the free will of another person. There is, in my view, a qualitative difference between having an honest discussion, even voicing one's concerns or disapprovals about a position on one hand, and on the other seeking improperly to put pressure on someone to act in a way they would not otherwise have acted. That I take to be, that word I take to be significant in the context of that draft offence.
Constable of St Saviour.
Yes, I think Deputy Morel has asked part of my question. I have a problem with this particular item regarding coerce. If it was obviously parents trying to look after their adult child, I think they would be more trying to plead not to do this as opposed to coerce. And that is a problem I have with this particular item, and I can't support it. So.
Thank you, Constable. Does any other member wish to speak on the fifth? Deputy Scott.
Sir, just to say, I feel more comfortable than the constable on this, because for me, I believe that coercion really is a form of bullying. I don't like the idea of the thought of anybody who's close to death being bullied into any decision. So for that exact reason, I will be supporting the panel's amendment.
Deputy Brennan.
Yes, sir. In a similar vein, I would say that the Constable of St Saviour, I would have said, should be reassured by the clarification offered by the Attorney General, which was that there is a huge difference between somebody pleading, having a discussion around those sorts of issues compared to coercion. And for that reason, like Deputy Scott, I feel fine.
Thank you. Deputy Howell.
Please, may I ask a point of clarification from the Acting Attorney General, sir?
Yes.
I was just wondering, if we do not vote for this, then is it correct that the 14-year jail sentence remains? Thank you, sir.
If I've understood the question, what is, I think, what has been suggested in the debate so far is that it is the proposed Article 46 offence that some members would prefer to have the chance to vote against. That offence is of coercing someone not to have an assisted death. That is punishable under the draft with a fine only. The other offence, the existing draft 45 offence, is of maliciously coercing someone to have an assisted death, for which, if it's adopted by the Assembly, the punishment will be maximum 14 years imprisonment.
Does any other member wish to speak on the Fifth Amendment? Deputy Morale.
So only actually to reiterate Deputy Balash's request of the Chair to hold this in two parts, this vote, when it comes to it. That's it. Thank you, sir.
Deputy Wilson.
Thank you, sir. I just wanted to ask the Attorney General for some clarification on where coercion is not coercion in the context of this statement, which is if you're sitting around, you know, the bedside having a conversation with your relative and you see the distress and you see that there may well be some uncertainty in them about the decision that they've made. And somebody says to them, do you want to change your mind about the decision? Is that coercion, or is that what he referred to earlier about normal discussion? And does he believe that the way in which the law is drafted at the moment actually safeguards and protects for that as it's written, or does it need something additional to qualify that?
Well, the illustration which the Deputy just gave doesn't sound to me like coercion. It sounds to me like a family discussion. Does the law as drafted provide enough safeguard? Well, it does, I think, in terms of the proposed text. The second safeguard, of course, is that a prosecutor has to decide first whether there is sufficient evidence to afford a realistic prospect of conviction, and if there is, whether prosecution is in the public interest. And it seems to me members must trust the prosecuting authority to do justice in each case appropriately according to the evidence and the public interest.
So,
Deputy
a follow-up question, is it correct to say that an additional safeguard is that presumably all of these offences we're discussing have to be proven beyond reasonable doubt by the court?
Of course, yes.
Does any other member wish to speak on the Fifth Amendment? If no other member wishes to speak, then I call upon Deputy Dublé to reply.
Thank you, sir. I'm grateful that the Minister has accepted this amendment and I acknowledge some varying views amongst members. I'm not certain myself, and I would, he's just left the chamber, but I'd quite like to just ask the Acting Attorney General if members were to vote against one of the articles, it would leave the draft law as it's written. Perhaps you could answer that yourself, sir. My feeling is that if members vote against any part of this, it actually leaves what the Minister has proposed. It doesn't remove the offence entirely. Are you able to answer that, sir?
Well, I'm not supposed to give legal advice to the Assembly. I think the Attorney is on his way back.
So,
Mr. Attorney, you thought you'd escape, but there is a further question from the Deputy Dublé, the chair of the review panel. Deputy Dublé, could you put your question again?
Yes, it's hopefully a simple one because I think I understand this, but I wanted to confirm if members vote against any part of this amendment, it won't actually remove the offences, well, it will leave the offences as they're written in the Minister's draft.
So can I raise a point of order? That seems to be a matter that the President of the Assembly can deal with. It's about a procedural matter rather than a legal one. It's axiomatic, I think, so that
Well, in that case, as a procedural matter, then the answer is yes. The offences remain, but if the Assembly doesn't approve them, then the word dishonesty will remain, and the proposed new offence of 46 would no longer appear in the text.
So may I have a follow-up point of procedural stroke order? Is that I would have raised it earlier in the previous one. There's nothing within this which stops us asking the Minister to take these articles separately when it comes to the vote, and some of us may well do that on this or other amendments if I think that's the right of the Assembly to have them
I think
voted on.
the first step is whether the Deputy Doublé is prepared to have separate votes on these two points. So we'll deal with that one first.
Shall I continue, sir?
Yes,
thank you. Yes, I see no problem with allowing separate votes on these. Yes, so I would suggest actually that the Minister also takes on board some of the points raised around the penalties for these offences, because it seems to me that actually this is something that could form part of the Minister's planned review as well, if members have some kind of maybe fairly minor questions that remain. I think that could be very well addressed by the Minister's review. But I wanted to just remind members that coercion is generally understood as the use of intimidation to compel a person to act against their will and requires illegitimate pressure that overcomes their free choice. So that is what would be at play here. Sir, I ask that I ask that members support this amendment. It has been carefully considered by the panel. It does differentiate between those two different acts, one which would have a very final and severe implication, and one which is slightly less so, still impactful, but less so than coercing somebody into ending their life. And we ask that the distinction between those two offences is made in this respect. And the use of the word maliciously, we feel, is much clearer than dishonestly, and as the Attorney General has clarified, it gives that very clear legal definition for somebody who has committed that offence. And Sarah, I ask for the appel, please.
Thank you. So the appel's been called for, and we will take it in two parts. So the first vote is in relation to the amendments to Article 45. And if members have had the opportunity of returning to their seats, I ask the greffier to open the voting. If all members have had the opportunity of voting, then I ask the greffier to close the voting. And I can announce that the Fifth Amendment has been adopted. 46 votes pour, no votes contre, no abstentions. In that case, we move on to debate 10 in the running order. Oh, I beg your pardon. So sorry. So sorry. I have missed the second part of the vote, which is in relation to the new Article 46. So, assuming all members have had the opportunity of returning to their seats, I ask the greffier to open the voting in relation to new Article 46. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. And I can announce that the vote in relation to new Article 46 has been adopted. 37 votes pour, 7 votes contre, and 2 abstentions.
Let's have the 7 and the 2.
7 on the 2.
Those voting contre, the connotabs of St Brelard, Trinity, St Peter and St Saviour, and Deputies Gorst, Miller and Andrews, and Deputy Balash and Deputy Wilson abstained.
Thank you. We can now move on to the 6th amendment, which is the 10th debate in the running order. And it is lodged by the chair of the Assisted Dying Review Panel. And I ask the greffier to read the 6th amendment.
Article 50. In Article 51A, for that breaches Article 78.3a, substitute in breach of Article 78.3a or 4. Article 78, 1. After Article 78.3, insert 4. But a person must not give the information described in paragraph 3a in writing at the place at which a doctor carries out general practice, unless the recipient is together in person with a health professional. 2. Renumber existing Article 78.4 and cross-references accordingly.
Deputy Dubé, would you like to propose the 6th amendment?
Yes, thank you, sir. This amendment arose from discussions around the section of the law that talks about where materials can be provided that give information about the assisted dying service and the prohibition on promoting the service. So we again had some very interesting discussions, because what wasn't immediately clear was how can this assisted dying service be communicated to people? How can information be put to people so that they understand, A, that the service exists, and B, how it works, and see how they might access it if they need it, without actually advertising the service or doing anything that could be seen to be persuading somebody to use the service. And I'm grateful to the Minister and his officers, because we had some good discussions and feedback and answers to our questions on this. And it was my Vice Chair, Deputy Catherine Curtis, who is a very thoughtful person and came up with the idea for this amendment after much deliberation. And what this amendment does is asks that materials that are explaining the assisted dying service, that they would only be available to members of the public where there is a doctor present in a GP surgery. Now, this amendment is very narrow in scope, and we've just addressed GP surgeries. And the reason for that is the healthcare setting that the majority of islanders, as the primary healthcare, is the healthcare setting that most islanders will more frequently be attending. So, and also what we didn't want to do was leave people kind of sitting in waiting rooms, perhaps going to the doctor for the first time about a condition, or feeling distressed about a condition that they have, and sitting there alone in the company of materials about the assisted dying service. We wanted to make sure that where people see that information, leaflets or posters, that they actually do so in a context where they have a medical practitioner present with them, so that they can immediately ask questions about it, and that clinical support would be present, because obviously doctors are very used to discussing healthcare with their patients, and if a doctor is there present in person, then he or she or they is very able to talk to the person and explain the palliative care options as well, and it wouldn't be taken as promotion. Now, this amendment is limited just to GP surgeries, partly because we're not able to address every single location, and we're also not sure exactly where the location of the service would be. But we also have a matching recommendation to this that asks the Minister to look at any other healthcare settings where information might be available and consider whether similar measures might be wise. So that's the effect of the amendment, sir. We're very grateful to the Minister for supporting it and for the discussions that we've had around it, and I hope that members will also support it.
Thank you, Deputy. Is the amendment seconded? Does any member wish to speak on the 6th Amendment? Deputy Ward.
Me.
Yes, Rob Ward.
Thank you, sir. It is a seemingly narrow amendment, one that restricts the provision of written assisted dying information within GP practices unless a health professional is physically present with the recipient. On the surface, it appears modest, but I ask members, when we look closely, it raises a series of practical, ethical and legal issues that must be considered. The panel's report explains that the intention is to avoid unintended distress and prevent the perception of promotion of normalisation of assisted dying in GP surgeries. Those are perhaps legitimate concerns. GP practices are indeed sensitive environments, but the amendment risks creating more problems than it solves. First, it introduces operational ambiguity into primary care. The amendment does not define who qualifies as a health professional, nor does it define what it means to be together in person. Does a nurse count, a healthcare assistant, a social prescriber? Must the leaflet be handed directly, or is being in the same room enough? These uncertainties will leave GP practices guessing, and when the stakes involve potential criminal liability under Article 50, guessing is not good enough. Second, despite the panel's assertions there will be no administrative burden, the reality will be different. Practices will need new protocols, staff training and redesign waiting rooms to ensure no written material is left accessible. And third, sir, we must consider the impact on patient access. Citizens Advice Jersey warned that some people, particularly those with disabilities, sensory impairments or limited internet access, may otherwise be in the dark about the new law. For many of these individuals, the GP surgery is the most familiar and accessible point of contact. By restricting written information to this one setting, we risk making it harder for precisely those people who rely on written materials to understand their options. Fourth, sir, there is a real risk of a chilling effect. Even though verbal discussions remain permitted, clinicians may be overly cautious. The fear of being perceived as promoting assisted dying may lead to GPs avoiding the topic entirely when the patient raises it. That would undermine the very principle of informed decision-making that this legislation is meant to support. Fifth point to make is the amendment applies only to GP practices, not hospitals, not hospices, not pharmacies, not community organisations. This creates an inconsistency that is difficult to justify. If the concern is unsolicited exposure, why is a hospital corridor acceptable but a GP waiting room not? If the concern is vulnerability, why is a hospice exempt? The amendment singles out GP practices without a clear rationale for doing so. So we must also consider equality and accessibility. The panel rightly emphasises the need for inclusive public information, and I completely agree. Yet this amendment may disproportionately affect older adults, disabled people, those with communication difficulties, and those who prefer written information before discussing sensitive topics. And that's a key point, before discussing sensitive topics. I personally, if there is something that is sensitive that I might want to know, I like to be informed beforehand, because it's my decisions that that will be important here. A safeguard, sir, intended to protect vulnerable people may in practice reduce their autonomy. Finally, the amendment introduces a legal uncertainty, and this is the real concern. By linking breaches of this rule to Article 50, we create the possibility of sanctions for what may be accidental or trivial infractions, such as a leaflet left on a desk or a printout handed over by a receptionist. That is not proportionate or clear regulatory framework. So the panel describes this amendment as least restrictive, but when we examine its effect, it risks restricting access, creating confusion, and undermining the clarity of the law. So we all share the goal of ensuring information about assisted dying is provided safely, sensitively, and responsibly. But safeguard must be precise, workable, and proportionate. This amendment, despite its good intentions, does not meet that test in my view. I urge members to reflect very carefully on the unintended consequences and consider whether this measure, as drafted, truly supports the informed, compassionate and accessible system we are trying to build. So at this moment, I cannot support this amendment. Thank you, sir.
Thank you, Deputy. Deputy Morrell.
Thank you, sir. I actually think Deputy Scott had a light on before me, just put it off.
Very well. Then Deputy Scott.
Thank you, sir. Yes, I share Deputy Rob Ward's discomfort on this, actually. I understand, and it was useful to know the circumstances in which this amendment was brought up by scrutiny, because it wasn't actually proposed, I understand, by one of the special advisors that they engaged for this process. What we basically have, I understand, is a problem and a concern, and a valid concern, which is that the subject of assisted dying needs to be introduced sensitively and appropriately. And I don't think anybody can deny that should be the case. But then we have a solution that has been proposed, and I think it's one of a number of solutions. And it's being considered that generally, when you are doing these things, you do need to look through all the options. Now, I am thinking in my mind about what I would think of the ideal way in which even this topic could be introduced to somebody who has a terminal illness. And I'm very much aware of the extra work that has been done by the panel, and many, in terms of end-of-life care. And for me, I would actually think it would be appropriate and sensitive and saying, well, look, you know, if you have a terminal illness, here are your options. And end-of-life care would be part of that. So, and then I kind of look, you know, this is a kind of a bit, so we're talking about a kind of package where actually really having people think about this, and that, you know, if it really gets too bad, you have this option of assisted dying, bearing in mind that many people don't go down that route in the end, because if they're satisfied with the end-of-life care or whatever, then, you know, that they won't choose it. So, and I do sort of think, well, are we being over-prescriptive here in terms of what I do generally trust is a subject that will be brought up sensitively? I can't quite see that. I imagine in my mind posters up in doctor's surgery saying, if you want to talk about assisted dying, you know, do it here and now, and take it out of context. So I will listen to the debate, but I have that shared discomfort for these reasons. Thank you, sir.
Thank you, Deputy. Deputy Morrell.
Thank you, sir. One of the things I find really interesting about all of the debates around assisted dying is, thankfully, we're all sitting here in the main as states members, not under kind of end-of-life stresses in the main. I mean, it's not 100% of the case, but we're here in the main in good health and good mental health and thinking through these situations. And yet, for a lot of people who are faced at that end-of-life choices, that isn't the case. The stresses upon them are enormous, and they're hard to understand for us, not in those situations. I have seen this through the eyes of my own family, and obviously other families as well. But, you know, the closest I have been, and I can only speak for myself here, other members will have their own experience, but the closest I have been to end-of-life choices are when my relatives, my closest relatives, have been faced with those choices. And so I'm learning, you know, as we do, from the experience of others. But thankfully, to date, I haven't been in that situation. And I can't help but feel that the scrutiny panel's amendment, which I do wholeheartedly support, really is thinking about that. And when you read the report and you see, I think they're quite right to point to the fact that people in a doctor's surgery, a GP surgery, sat in the waiting room, are in a very different range of mindsets at that time. Some of them will be there quite likely, just dealing with small matters which aren't worrying them. Other people will be there, you know, having or about to receive some life-changing news. It is a particular moment in time when you're sat in the doctor's surgery's waiting room where you don't, and I've often thought this myself, I don't know what the person next to me in the waiting room is suffering from. I've been lucky to date that every time I've gone in the main to the doctor's surgery, it hasn't been anything particularly serious. But the person next to me could be suffering from horrendous cancers and other things. And you just don't know that. You're just sat there in the doctor's waiting room together, and understandably, well, I don't share what I'm there for. So I do understand why the scrutiny panel has said, you know, if you're sat in a doctor's surgery room, and most of them do have posters, we know this, and leaflets, and you are faced with leaflets about assisted dying, I do think that could be really quite perturbing for people in particular mindsets at that time. And I do think it would be something that, you know, I've just lost my mother to dementia, and I've just had my father diagnosed with dementia. And I know that having watched my mother go through that process, and sadly going to watch my dad go through a similar process, there is immense confusion caused in those times. And should he be sat there in a doctor's surgery for a regular appointment, faced with a poster or a leaflet talking about assisted dying, I think that could have a very damaging or he could end up creating quite damaging interpretations of the reasons for those posters being there. I was particularly disturbed in the scrutiny panel's report about Citizens Advice Jersey's suggestion that actually a mail shot should be sent out. And so I fundamentally disagree with Deputy Rob Ward on this issue, is the idea that a mail shot would be sent out to people. Obviously, it's impossible to know what mindset the person receiving, you know, 100,000 people receiving such a, unexpectedly receiving such a matter through the post. Some people, particularly those with dementia or other neurological diseases, could absolutely interpret that as a promotion for something that they should be doing. And that is incredibly dangerous. So I'm quite concerned that Citizens Advice have suggested that that would be an appropriate way forward. I also compare that, and I think it is worth comparing, that with, you know, other options that are available. It is interesting that Deputy Rob Ward, and he made a really good speech, and I congratulate him on that. I thought it was a very good speech. I'm not criticising him in any way. I think he holds a particularly reasonable perspective. It's just one I disagree with. And I don't see the call for, you know, other end-of-life options being promoted. I don't hear a call for my rights today, before the passing of this law, for me to have, you know, to be sent information about palliative care, about the other end-of-life options, about my rights that I have today. Nobody in the 8 years that I've stood in this assembly has suggested at any point that I should be sent information about my rights as they stand today about my end-of-life options, in order to increase my personal autonomy in choosing those options. And so I can't help but feel there is, again, this kind of two-level debate going on, whereby assisted dying is almost, and there are times in this assembly as I've listened to the various debates, there is almost a desire to promote it, when existing options, it's quite the opposite. They are not being promoted. They are very rarely looked at. And and I really want to make sure that is not a criticism of the current system or the current way things are working. It's just a statement of fact. In 8 years, in fact, in my lifetime, I don't think I've ever received a mail shot suggesting anything about my end-of-life choices as they stand today. And so I am concerned about the vigour with which some people are suggesting the importance of getting this information out to different people. I think it is right that the information around assisted dying, if the law is passed, and I've no doubt that it will be passed, should be conveyed to those people to whom it matters the most in a very careful way, in an appropriate setting. And I think in this case, clinical settings or settings with other support, you know, whether it's through groups such as Macmillan or Dementia Jersey or the many other charities and organisations that help people at that point in their life. I think those are the ways that these sorts of bits of information should go through, because at the end of the day, when it is just random posting of posters on boards or leaflets in waiting rooms or mail shots through letterboxes, it is absolutely impossible to know the mindset of the person receiving that information, and therefore the way in which they will receive that information. The only way it is possible to know that is to be in a carefully managed clinical setting or similar. And so for those reasons, I absolutely support this. I think it's definitely the right thing to do. And I actually think, should I be re-elected in the elections later this year, I actually think this will be something I look at in the main and think about, and I'll discuss with the health ministers, etc., whether there should be a wider limitations on the kind of promotion, for want of a better word, of assisted dying, because I think it is something we do need to think about. So I shall be supporting this amendment. Thank you, sir.
Thank you, Deputy. The next member I have to speak is Deputy Catherine Curtis, followed by Deputy Terdier.
Thank you, sir. I'm pleased to follow Deputy Morell, who made a very thoughtful speech. Deputy Rob Ward and others raised concerns about legal uncertainties around information sharing, and that is not a valid argument. This will all be clarified in the guidance. There is plenty of guidance to follow from this legislation. Deputy Ward also raised the matter of just GP surgeries being part of this, but I don't know if he heard and understood the Chair's speech, which fully addressed this matter. And of course we discussed this with the experts, and their response is that they consider this could be a guiding principle for other jurisdictions. I'm pleased to see that the Minister has accepted this amendment. And during the many meetings held by the review panel and during our discussions, I tried to imagine myself in the place of a person who has a terminal illness. And of course, no one knows what that's like until you're actually there, but we have to try and empathise. And I pictured myself going to the doctors for an appointment and being confronted in the waiting room with leaflets about assisted dying. So something like this could prey on a person's mind, even if they have never considered an assisted death. We have to remember that people can be diagnosed with a terminal illness, but then go on to live much longer than expected. A member of my own family was given a terminal diagnosis and then went on to live fairly well with cancer for another 10 years. And perhaps towards the end of that time, he may have considered an assisted death if it had been available. But before that, he would not have wished to give it any thought. So I would not want assisted dying presented as an option when someone would otherwise never have considered this, especially when they're in a vulnerable state through illness and perhaps visiting the doctor. At the very least, assisted dying should be considered while there is expert professional advice available. So the review panel has recommended this amendment on information about assisted dying, and that it is used as a guiding principle for all places where people may seek support and guidance on health matters.
Thank you, Deputy. Deputy Terdier.
So whilst I don't agree with necessarily the conclusion that Deputy Morell came to, I think he did give us pause for thought, and I think it's true that any literature or information that's being sent around can have an impact and can be a trigger for some people as well. I'll just give one example. Recently I've had to start going to Springfield Gym. I used to go to Fort Regent, but that's no longer there. That's not a broadcast against Fort Regent, by the way. And there's a poster when I come out of the gym which says, a big poster says, are you thinking about suicide? And part of my reaction is, no, I wasn't, but I am now. And although that's a poster there which is supposed to be to call out for people who might be thinking of it, say, actually, there are other options, come and talk to us, and there's a helpline, immediately my thoughts go to, and that could be interpreted in different ways. So I'll just leave that thought there, because it can, even a poster like that, which is well-intentioned, and I think no one would necessarily disagree that that poster's got the right to be there, can have an impact on somebody who's who's relatively well-adjusted, I think. Coming out of the gym, I may not be coming out of here later today, sir. So the question then comes to me is the other side of the coin, where I do have some sympathy for the comments that Deputy Ward made earlier, is that are we just perpetuating the already inherent taboo that we have certainly in Western society nowadays towards death? Because by saying that you can't have basic information about something that we're quite happy to discuss in a public forum, that will be publicised on the front page of the JEP tomorrow, presumably. I mean, if we pass this law, it's big news, it's quite right. That'll be on the front page of the paper. It will be on the news broadcast, sir. But we're saying, but we shouldn't publicise this. So a leaflet can't go out to tell people that now, when this actually becomes a thing, that there is an assisted dying service. And there is an extreme example of this in fiction, of course. I remember in my teenage years, I read the dystopian novel by Aldous Huxley, which was Brave New World. And on the surface, it seems like a utopian world that's presented to people, but it very quickly becomes apparent that it's a dystopian world. And it's a world in which youngsters are conditioned from a very young age, indeed from the first few weeks, and in some cases from before birth, to either fear certain things or to be very comfortable with certain things. So, for example, the lower castes, I think, are discouraged from an early age from ever associating with books and flowers, because they don't want them to become accidental intellectuals. And on the other hand, youngsters are also conditioned quite quickly to not fear death and to just see death, to treat death very indifferently, to the point that then they're not even allowed to mourn the passing of a loved one. And of course, so that's an extreme example. I fear that in some ways where the other extreme, where we perpetuate a taboo around death, to the point which we're having a debate now and an amendment saying you're not allowed to put a leaflet in a public surgery, or probably at the hospital, saying that assisted death is an option. And I'm just not sure if that ultimately in the future will be seen as overly cautious. Again, I'm not making direct comparisons here because, of course, we can never do that. But there may well have been a time, for example, in a different context where before divorce was widely socially acceptable, and whilst it might have been legal, that it might have been seen as a taboo to have a leaflet encouraging women to come forward if they're being abused domestically and encouraging them to leave their husbands and leave their partners, because that might have been seen as encouraging separation and divorce. I think nowadays we'd find that very strange and very antiquated. So I'll leave that example there. I don't want to start to get into other areas, but I also am mindful of the fact that when you go to a doctor's surgery or indeed the hospital, you might be going there with someone else. You might be going there as a young person who's years away from death and is not actually contemplating death in any way. And you might actually be able to pick up a leaflet when you're in your 20s and you're actually accompanying an elderly relative there. And you might be able to read a leaflet about the assisted dying program when you're much younger, even though you're not going to be considering it for yourself before hopefully maybe 50, 60 years or never. And I think that is the counterfactual which we have to balance up here, sir. So the long and the short of it, sir, is that I'm happy to support this recommendation from the panel, and I think it's supported by the Minister as a step. But I think we do have to be very careful of the message we're sending out, that there is a balance to be struck about providing information in a clear way. And I don't accept the fact that simply providing information is the same as encouraging, and of course encouraging is not the same as coercing. So I think we need some sense in this. It will be something that's monitored. Similarly, I wouldn't want to see any doctor's surgery get prosecuted if somehow some leaflets accidentally found themselves in their way into a doctor's surgery and somebody picked it up and felt scandalised by it, sir. So I think that there needs to be some common sense applied in all of this.
Thank you, Deputy. Does any other member... you have a question,
I've got a question
for
for the
Attorney.
AG.
Deputy Scott.
So perhaps the Attorney General might confirm that if this law comes into force, if it's with this proposed amendment, and if it's reported by the press, that in itself won't be in breach of this on the basis that advertising, promotional advertising is not the same as reporting. So similarly, if there's information on the government website, for example, for anybody who wants to just find out about the service, if that could be confirmed, please, sir.
Tony?
Well, what is permissible in terms of publication is found in Article 78 of the draft law. The Article 50 offence arises where matters are published otherwise than in accordance with paragraph 3 of Article 78. Paragraph 3 provides that a person who in any way, including in writing or by broadcast, promotes or advertises, and journalistic reporting seems to me is neither of those things, but anyone who promotes or advertises assisted dying or the service may do so only by giving information, first, about the availability of assisted dying and related services, second, about where more information on assisted dying can be found, third, about their role in assisted dying, or fourth, that supports awareness and understanding of assisted dying, and B, must not do so with the intention of persuading or encouraging anyone to have an assisted death. So those are the permissible boundaries of what can be said publicly about assisted dying. I do not take journalistic endeavours to be either promotion or advertisement of the service. They are news reportage.
May I ask a
Rob
question?
Ward.
Thanks, sir. Just to confirm that the rule applies as this article is. Sorry, I'm trying to get my words together here to make some sort of sensible question that might be answerable. It says writing at a place in which a doctor carries out general practice, unless the recipient is with a health professional. Can I ask, sir, the Attorney General, so if this information is elsewhere, in the corridor of a hospital, in a community centre, would those people be breaking the law under this article, or is it just doctors' surgeries? Thank you, sir.
This amendment refers only to a place at which a doctor carries out general practice. Whether that's a doctor's surgery or whether it's in some other health provision facility where the doctor is carrying out general practice is not really for me to say. That the extent of the policy consideration is for others, but that is the effect of this article. It's only about within the context of a doctor carrying out general practice. So perhaps while I'm on my feet, I should just correct one other matter which I hope is of assistance to members. The definition of health professional does in fact appear in Article 1 of the draft law, where it means a doctor, a nurse, a pharmacist or pharmacy technician, a dentist, optometrist or dispensing optician, meaning a person who is professionally registered as that, or an occupational therapist, physiotherapist, social worker or speech and language therapist, or a person in another registrable occupation under the healthcare registration law. In each case, meaning a person who's professionally registered as that. So although the definition of health professional doesn't appear in the new draft article, it does appear in Article 1 of the law.
So can I ask an additional question of the Attorney
The
General?
Constable of St Mary had his light on first. Did you have a question for the Attorney General, or did you wish to speak?
It was not for the Attorney General.
Right. Well, and then in that case, Deputy Coles first, I think.
Thank you, sir. The AG just clarify then, because obviously we have a debate on P15 2026 coming up in the coming weeks about registered professionals. Would this law apply to all members of that professional register should that be adopted?
Well, without having that law open in front of me, and I can't answer the question. All I can say with confidence is that for the purposes of this Article 78(3), what the meaning of health professional is for the purposes of this law, because the meaning of health professional is set out in Article 1 of this law. I can't assist further than that.
Deputy Scott.
So I just wish to ask about the position if you had a consultant like an oncologist. So if they are with somebody who has a terminal illness and wants to discuss options in terms of care, does my interpretation of this mean that they need to go to where a doctor carries out general practice to actually give out that information? Because
So, no, I don't take it to mean that. What I take this to mean very narrowly is that if you are in a GP surgery, you cannot have in writing at that place information about the service unless it's provided to a person in person who is there together with a health professional. And that's all I take it to mean.
Constable of St Mary, you wish to speak?
Thank you, sir. It actually follows on from the questions raised with the Attorney General. I have some sympathy with Deputy Ward's original contribution in his statement that it is a very limited area which is protected, and that my major concern is simply, sir, that it's not only doctors' waiting rooms that people are waiting for treatment, it can be the pharmacy next door. In fact, it might even be the pharmacy which is owned by the doctor's surgery, and I think there's as great a danger waiting for your prescription in a pharmacy, and elderly people may go to a pharmacy more often than they go to a doctor. And I take note of the point that a health professional includes a pharmacist, but I take it also that a pharmacist can't be deemed to be there in person if they're simply on the counter and someone else is sitting in a chair sort of 10 yards away. I shall be supporting it, but I simply ask the Minister to bear that in mind as to whether some dialogue needs to take place with the pharmacists to make sure that they are observing the same rules effectively. Thanks, sir.
Thank you. Deputy Stevenson.
Thank you, sir. And I just wanted to respond to something that Deputy Tadier had raised in his speech, and I think we probably ended up at a similar place at the end of it, but by then it had already triggered me and I decided I was going to say something, so apologies, Deputy Tadier. But it was just to really put on record, because I think it's important when we're talking about these things in the Assembly, and there is a public record of it, that actually there's an awful lot of evidence out there that says that talking about suicide does not increase the risks of people taking their own lives, and that it is very much a myth that that's the case, and actually an ongoing damaging myth, and it might have the opposite effect on people. So I just wanted to make that absolutely clear, that in modern times, recent times, the studies and the research all points that if we talk about suicide and ask that question and put those posters up, actually it has a positive effect rather than a negative one.
Would the member give way at all?
Yeah, absolutely.
Yeah, and in my clumsy way, I think that's what I was trying to say, is that the net benefit is there, and I was trying to make a similar point for this. Thank you.
And I appreciate that, and I think that's what I took from by the time we got to the end of the speech. So yeah, I'm glad we agree on that. Absolutely. But then thinking this through, just some of the questions we've then had since that have raised in my head the question about, and perhaps it's something that the proposer could respond to in her closing, about why we need this to go into the actual law, and could it not form some guidance? I presume there's going to be a need for a significant amount of guidance around a law like this, and actually that would allow it perhaps to apply to broader places. It would allow it to be a bit more movable as well, with a new, when we've got a new law like this coming into play. It's something that we're going to need to reflect on regularly, and I just wonder, I think I'm left with that question about, does this very specific bit need to be in the law itself, or could it form, are we tying ourselves in more knots than we need to by putting it in the law? Could we actually do it in another way, and that it makes it a bit more pragmatic going forward? Thank you.
Thank you, Deputy. Deputy Coles.
So I hate to be troublesome, but can I ask the Attorney General just for one clarification? Well, I'm going to, if I may. I spoke in my speech about this being limited to GP surgeries, and I still believe that to be right. Well, I understand the idea of anywhere a GP performs their duties. So, for example, they may use a community centre as a GP surgery at certain times, or somewhere. But can I ask, if information is displayed in somewhere that is not a GP surgery, the corridor of a hospital, the pharmacy waiting room, the I don't know, a myriad of other places, maybe community centres, citizens' advice centre, would that be in breach of this law because there is not a healthcare professional available, or is just specifically, because I read this as GP surgeries because that's what it says in the comments paper, sir. I just need to be very precise. I think it's important that we are. Thank you, sir.
Thank you, Deputy.
No,
Mr. Attorney.
The purpose of this Article 78.3 is to provide a carve-out from the provisions of Article 78, which I quoted earlier, and paragraph 3 of that article, about giving information about assisted dying. And I'll read it again. That provides that a person who in any way, including in writing or by broadcast, promotes or advertises assisted dying or the service, may do so only by giving information about the availability of assisted dying and related services, about where more information on assisted dying can be found, about their role in assisted dying, or that supports awareness and understanding of assisted dying, and they must not do so with the intention of persuading or encouraging anyone to have an assisted death. This provision is designed to carve GPs' surgeries out of Article 78. In other words, you can do all those things that Article 78.3 permits you to do, but you mustn't do them in a GP surgery.
So, Deputy Coles.
Thank you, sir. I rise after the Constable of St Mary's made the point about the pharmacist and the questions around the register of health professionals, because obviously we have got this proposition coming before us in a couple of weeks, which will clarify and tidy up the register to make it clear what a healthcare professional in Jersey is. And actually, the Attorney General there has clarified this point up quite clearly. For me, I think it is right that we don't have this material publicly available within a doctor's surgery, because it is part of the whole treatment. There are the ways and things to which it can influence people's decisions. One of the key parts that I found with the assisted dying debate we've gone through in this term was about the fact that it was all opt-in, that doctors aren't going to be made to take part in this. And so if we're starting to advertise in their surgeries which doctors are taking part on this, it might prejudice some people from feeling safe within their GP that they don't want to carry out this service. And I don't want anybody in this island to feel that they are feeling that they can't trust their GP, because this is the first point of contact we have in primary health care, and I think we need to strengthen that support. So I think this carve-out is an important thing to do, because I think people should feel that they can trust their GP, whether they choose to have an assisted death or they don't. So I will be supporting the amendment.
Thank you, Deputy Coles. Deputy Balash.
So I think that this amendment is quite a moderate amendment, because Deputy Rob Ward is quite right to point out the inconsistency between a hospital corridor, for example, and a doctor's waiting room. But it does seem to me that this amendment points a cautionary finger. It achieves, of course, what it purports to achieve on the surface, but it also points a cautionary finger at the hospital authorities, because I think it would be very undesirable, even for hospital corridors, to be plastered with posters advertising assisted dying, and I'm sure the Minister agrees. And I'm sure that, as a matter of discretion, that will not happen. Because discussing this subject is really a sensitive issue, which really ought to be done in the context of a discussion between a between a medical professional and the patient. And I'm sure that in practice that will be the way in which things are dealt with. But I did want to make the point that this is a moderate amendment. It could have gone much further, and I hope that members will support it.
Thank you, Deputy. Does any other member wish to speak on the 6th amendment? Minister.
So I'm glad to see that this afternoon I'm aligned again with Deputy Balash. I think this is really the start of a process. It establishes a guiding principle. I think if this all goes through today, there'll be an 18-month implementation period. I'm sure we're going to give this more focus. And I think that the critical question is, do we want to be sensitive about this or don't we? Deputy Curtis and Deputy Morrell spoke very meaningfully on the subject. I think some of the speeches perhaps lost their way a bit. This isn't really the same as divorce or domestic violence, because I like to think there's always a way back from those two situations. And sadly, in the main, terminal diagnosis is something very different indeed. And I think we do have to put ourselves in the shoes of people confronting that. I'm sure that at some point in time it'll affect a number of us, and I'm sure that if you've just received that sort of news, you don't really want to be sitting waiting to see your doctor the next time, staring at a poster in the doctor's surgery, putting that right in your face. I just don't think that's appropriate. I think this is about taking a sensitive approach to the whole subject, and we've been aligned with scrutiny on this, and I hope members see fit to support it. So, thank you.
Thank you. Does anyone other member wish to speak on the Sixth Amendment? If no other member wishes to speak, then I close the debate and I call upon Deputy Dublé to reply.
Thank you, sir. I wanted to clarify that this amendment is solely focused on GP surgeries. Some of the speeches, I think, perhaps missed maybe my opening speech where I clarified this. So I wanted members to be absolutely clear that this would only impact on waiting rooms for GP surgeries. Furthermore, the advertising, providing materials wouldn't be banned completely from GP surgeries, but it would be permitted in the doctor's office where the doctor is present. And as Deputy Balash mentioned, it is a balanced and proportionate amendment. Which has been discussed with our advisors, as my Vice Chair pointed out, and developed in conjunction with them. And again, my Vice Chair, and I thank her, she addressed many of the points raised by Deputy Ward and some others, and I thank her for that. And Deputy Morrell, I thought gave a very powerful speech, and he used the phrase "a particular moment in time" to describe people's experience of GP surgeries, and that's exactly the reason why I think Deputy Curtis raised this in the first place, and why the panel agreed to take it on after consideration. I think, sir, and I hope that members will have looked at the report as well as the amendments, because actually I think every single point that was raised is addressed in significant detail in the 12 pages of evidence and analysis on public awareness that we have provided in our report, and a full suite of recommendations that applies to public awareness as well. I'm not going to read all of them out, sir, because they are available to members in the report, which everybody has, but recommendations 23 to 28 cover the public awareness recommendations and include things such as an accessibility annex attached to the guidance, which would cover audio, large print, easy to read, plain language and non-digital distribution for inclusion and accessibility purposes. We've also, as I mentioned in my opening speech, one of our recommendations asks that the Minister generalise this principle to other healthcare settings. And the members can read for themselves the other recommendations, which again I hope that the Minister will action those, because there is a clear action plan there in terms of what is reasonable in the panel's view in terms of public awareness. And so one further point around the definition of healthcare professional, this is actually defined within the law, the Minister's draft law itself in Article 1, so the panel is satisfied that that is clear. And I propose the amendment, sir, and ask for the appel.
Thank you. The appel is called for, so I ask all members to return to their seats. All members have had the opportunity of returning to their seats. I ask the greffier to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. I can report that the Sixth Amendment has been adopted. 42 votes pour, 3 votes contre, and no abstentions.
Those voting contre, the Connétable of St Lawrence and Deputies Tadier and Rob Ward.
Thank you. We move on now to the Seventh Amendment, which has been lodged by the Assisted Dying Review Panel, and I ask the greffier to read the Seventh Amendment.
Article 62, 1. After Article 62, 2G, insert H, how to identify, I, risk factors that increase the likelihood of someone's exposure to coercive control or domestic, emotional, financial, or other types of abuse, such as their sex, sexual orientation, gender identity, age, disability, or socio-economic disadvantage. And 2, whether someone has been coerced or pressured to do something. 2, renumber existing Articles 62, 2H to M and cross-references accordingly. Article 63, for Article 63.2, substitute 2, there must be general guidance, A, about how to identify, 1, risk factors that increase the likelihood of someone's exposure to coercive control or domestic, emotional, financial, or other types of abuse, such as their sex, sexual orientation, gender identity, age, disability, or socio-economic disadvantage. And 2, whether someone has been coerced or pressured to do something. And B, for families and carers of an individual. Article 65. Article 65, 2C, substitute C, how to identify, 1, risk factors that increase the likelihood of someone's exposure to coercive control or domestic, emotional, financial, or other types of abuse, such as their sex, sexual orientation, gender identity, age, disability, or socio-economic disadvantage. And 2, whether someone has been coerced or pressured to do something. Article 66, 1, for Article 66, 1A, substitute A, must arrange with a service or another supplier to develop or change training on 1, how to identify A, risk factors that increase the likelihood of someone's exposure to coercive control or domestic, emotional, financial, or other types of abuse, such as their sex, sexual orientation, gender identity, age, disability, or socio-economic disadvantage. And B, whether someone has been coerced or pressured to do something. And 2, having appropriate conversations with patients about assisted dying. 2, after Article 66.1, insert 2, the training described in paragraph 1A1 is to be provided on an ongoing basis to agencies and services for which the training is relevant, such as Jersey Domestic Abuse Support. 3, in existing Article 66.2, for the training, substitute the other training under this article. 4, renumber existing Article 66.2 and cross-references accordingly.
Thank you, greffier. Deputy Dubert, I invite you to propose the Seventh Amendment.
Thank you, sir. I'm getting a bit of deja vu at this point. I should do my best to be brief. I wanted to, before I go into the content of the amendment, I wanted to make references to 2 things. One being the Vorg report, which the Minister seated in front of me I know is very familiar with now, and indeed the Assembly has taken ownership of it. And I wanted just to acknowledge and make a nod to the Violence Against Women and Girls report and the task force and the awareness that they have raised around the incidences of coercion and how that relates to domestic abuse and how common it is. Because were it not for the work of that task force, which of course was initiated by one of my panel members, Constable Shenton Stone, and we would not have had the knowledge and understanding to actually even be able to start asking questions, I think, to the extent that we could. So we're very grateful for that work and the continuing work there. Another thing I wanted to mention is that the minister, I believe, very early in the process, before we actually, I think this was before we actually formally launched our review, where the minister gave us some additional confidential information about the draft legislation that was still being worked on. And at that point, I believe the panel gave some feedback around the collection of data around personal characteristics of people who are accessing the assisted dying service. And I believe that was that has already been written into the legislation. And that's important because understanding people's personal characteristics is important for this amendment, and I will explain why. And I thank the Minister for making that addition. And I also thank the Minister for accepting this amendment. I think one of 5 amendments of our 7 that we have lodged that the Minister is accepting. And so this is very much a safeguarding amendment and strengthens the safeguarding elements of the legislation. And it would ensure, if adopted, that mandatory training and guidance would explicitly cover coercive control, domestic and emotional abuse, financial abuse, undue influence, and risk factors linked to characteristics such as sex, sexual orientation, gender identity, age, disability, and socioeconomic disadvantage, but not limited to those characteristics, because of course there are other characteristics that people can have which perhaps make them more vulnerable to abuse. It requires that the Minister would ensure that this training is not just provided to the clinicians that are directly involved in providing the assisted dying service, but to all relevant agencies, because it's an all eyes on approach, and that any health professional, any professional that might be coming into contact with somebody who may be accessing the assisted dying service has an opportunity, and indeed we feel a responsibility to be on the lookout for domestic abuse and coercive control where it may be occurring. And the ultimate purpose of the amendment is to reinforce that any assisted dying request should be free and voluntary and free from any kind of pressure. And the Vaughan report has shown us how widespread domestic abuse is. And I have tried with some recent written questions actually to try and compare the frequency of domestic abuse in Jersey compared to places such as the UK. And it's very difficult to actually find this. I did find some initial evidence that showed Jersey has a higher rate, but certainly there are high rates in Jersey. And the Vaughan report found that more than 85% of victim survivors in Jersey actually experience emotional or psychological abuse as a component of that of their abuse. So it is very common, and it's often hidden, and it's often so hidden that actually sometimes nobody knows that it's happened. It's never reported. Coercion can be so subtle that it can be really hard to detect. It's relational, so it involves an understanding of the relationships between people. It's often not physical at all. So sometimes when we think of abuse, we think, oh, we will see marks or we'll see some kind of signs, but there might not be any physical indications whatsoever. And it's really important that frontline professionals are equipped to recognise this in any kind of clinical and care interactions. And the reason why we have included the personal characteristics in here is that there is actually unequal risk across the population. As a queer woman myself, this is research that I have found really interesting, but actually quite upsetting at times to read and to learn about the different rates of domestic abuse that are experienced in different types of characteristics. Women, we know, are at much higher risk, but also in the LGBTQ+ community, over 1 in 10 will experience domestic abuse, and bisexual women are actually at a far elevated risk for that. And understanding these risk factors is really important, because if a doctor doesn't know these characteristics that their patient actually has, then they can't actually be aware of it to be on the lookout for domestic abuse and potential coercion. I could go on, and I could talk about age, disability, socioeconomic disadvantage is another one that is often really hidden and puts somebody at greater risk for abuse and coercion. And individuals may be masking or minimizing this abuse and coercion, so the training needs to be really targeted and designed to help professionals unpick and uncover anything that is happening there. So the training would be mandatory, sir, if this amendment is accepted. It wouldn't be optional. It would go into detail and examine the demographic risk factors that I have explained on how to spot subtle and relational coercion, and it would enable practitioners to apply a trauma-informed and an inclusive safeguarding approach. So, Sir, again, I'm very pleased that the Minister has accepted this. I think actually of all our amendments, for me personally, this is the most important, because this is the one that has the most chance of protecting those in our society who are most vulnerable. And I wholeheartedly recommend this amendment to the Assembly, and I hope that it is strongly supported.
Thank you, Chair. Is the 7th Amendment seconded? Does any member wish to speak on the 7th Amendment? Deputy Rob Ward.
Thank you, sir. Yes, sir, and I'm very pleased to follow the chair of the panel and on this occasion support this amendment, because I think it does strengthen safeguards and assisting dying. I think it's very important in this assembly that we do have discussions about those groups in our society that are most vulnerable, and we need to be very careful in our actions that we don't make those groups more vulnerable from the decisions that we make in this assembly. And this is a decision to ensure that those groups are less vulnerable. So I'm very happy to support it. I was very pleased, I'm not going to say much else, but I was very pleased to hear the phrase mandatory training. I think sometimes we do not do that enough. If it's important, let's get people to do it, let's support it, and let's ensure that it works. So I'm very, very pleased to support this amendment. Thank you, sir.
Does any other member wish to speak? Minister.
As articulated, this amendment very clearly doesn't leave anything else for me to say other than that I fully support it. So, thank you.
Thank you, Minister. Does any other member wish to speak on the 7th Amendment? If no other member wishes to speak, then all those members in favour of the amendment kindly show.
The appeal's been asked for.
I need to sum up first.
I'm sorry. Deputy Dubé, please would you reply?
Thank you, sir, and I think we can all be patient with each other and understand that this is a very complex process with the legislation that we're debating today. I thank members who have spoken, particularly the Minister, and I wanted just to point members' attention to Recommendation 7, which makes a further recommendation that actually would apply to states members as a group, that we could get some of the disaggregated data around the characteristics of people who are accessing the service in confidence if necessary, so that there is that oversight of those characteristics and to clinicians as well. So there is further strengthening within our recommendations as well as this amendment. I recommend the amendment to the Assembly, sir, and I hope members will support it.
Thank you, Chair. I thought I heard the appel being called for. Is the appel called for? Yes. If all members, could I invite all members to return to their seats. If all members have had the opportunity of returning to their seats, then I ask the greffier to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. And I can announce that the 7th Amendment has been adopted. 44 votes pour, 1 vote contre, and no abstentions.
Econ Club of St Lawrence.
Thank you. So we move on to debate 12 on the running order, and that relates to section G of the second amendment, which is proposed by the Minister for Health. So I ask the greffier to read section G of the second amendment.
Article 72. In Article 72(2), for as allowed by, substitute in any of the circumstances described in. In Article 87, in Article 87(2)(b), for as allowed by, substitute in any of the circumstances described in.
Minister, I invite you to propose section G of the second amendment.
So, as part of the panel's review process, the General Medical Council questioned whether the disclosure provisions that allow for the sharing of information could be interpreted too narrowly. Reflecting on that feedback, this part of my amendment clarifies when the Assisted Dying Service and the Assurance and Delivery Committee may share information, including with the consent of the individual, to protect an individual's safety, for regulatory, disciplinary, investigative or enforcement purposes, or where required by law or court order. It puts beyond doubt the fact that professional regulators, whether in Jersey or elsewhere, can access the information they need to fulfil their statutory duties, sir. And on that basis, I commend that to the Assembly and hope that they vote for it, sir. Thank you.
Thank you, Minister. Is section G of the second amendment seconded? Yes. Does any member wish to speak on section G of the second amendment? If no member wishes to speak, then I would ask, the appel has been called for. I invite all members to return. I invite all members to return to their seats, and I ask the greffier to open the voting. If all members have had the opportunity of casting their votes, then I ask the greffier to close the voting. And I can report that section G of the second amendment has been adopted. 42 votes pour, 2 votes contre, and no abstentions.
Those voting contre, the Conotub of St Lawrence and Deputy Balash.
Thank you. Now we move on to debate 13 in the running order. And that relates to section F of the second amendment, again lodged by the Minister for Health and Social Services. And I ask the greffier to read section F of the second amendment.
Article 74, 1, after Article 74(1)(b), insert C, the number of individuals who, at step 6, made their final request for assisted dying and waived the requirement for future capacity. 2, after existing Articles 74(1)(f)(2), insert 3, whether at step 7 the practitioner was not satisfied that the individual had capacity to make a final request for assisted dying, but the individual had at step 6 made their final request for assisted dying and waived the requirement for future capacity. And 4, if clause 3 applies, whether the individual showed any refusal of or resistance to the approved drugs administration, meaning that their assisted death was not carried out. 3, renumber existing Articles 74(1)(c) to 1 and cross-references accordingly.
Thank you. Minister, I invite you to propose section F of the second amendment.
So, in order to strengthen transparency, this part of my amendment makes it explicit on the face of the law that the annual report, which is a legal requirement, must include information related to the number of individuals waiving the requirement for future capacity, including how many proceed to an assisted death and how many show signs of refusal or resistance, so do not have an assisted death. Reporting on matters related to the waiver is already allowed for under Article 74. This amendment brings forward an explicit requirement to support monitoring and assurance, and I ask members to support this, sir. Thank you.
Thank you, Minister. Is section F of the second amendment seconded? Does any member wish to speak on section F of the second amendment? If no member wishes to speak, then I ask members in favour of section F. The appellate call. I ask members to return to their seats. If all members have had the opportunity of returning.
I'm ahead of the game, so I was pushing my button prematurely.
I'm taking this slowly, Chief Minister.
I appreciate that, sir. Thank you.
Perhaps too slowly for you, but I ask the greffier to open the voting. If all members have had the opportunity of casting their votes, then I ask the greffier to close the voting. And I can report that Part F of the second amendment has been adopted. 44 votes pour, 1 vote contre, and no abstentions. Very well. We move on to the 9th Amendment, which is debate 14 in the running order. And the 9th Amendment has been lodged by the chair of the review panel, and I ask the greffier to read the 9th Amendment.
Article 74. For Article 74.4, substitute 4. The Minister must, as soon as reasonably practicable, after receiving a report, A, consult the Medical Officer of Health about which information should be excluded under subparagraph B. B, prepare a version of the report, the public report, that excludes 1, any information described in Article 41(1)A or C, allowing identification of people or approved drugs, and 2, any information described in Article 41(1)B about the carrying out of an individual's assisted death, that is of a private nature, such as information about any medical complications during or after the administration of the drugs. C, present the public report to the States Assembly, and D, publish the public report, 1, electronically, including on a website maintained by or for the Minister, and 2, in a style and format that is accessible, meaning that the individual or group for which it is intended is able to read or receive it and understand it, and which may include alternative formats such as large print or braille.
Thank you. Deputy Doublé, I invite you to propose the 9th Amendment.
Thank you, sir. This is a fairly simple amendment which it requires the Minister to publish his report every year and actually present it to the States Assembly. So it just gives that improved oversight for States members, for the Assembly to actually receive that report. It would require that anything that needs to be redacted, such as personal information or the actual detail of which particular drugs are used, that would be redacted. And it also requires that the report be made as accessible as possible. So I hope that members will support this amendment. I thank the Minister for accepting it as well.
Thank you. Is the 9th Amendment seconded? Does any member wish to speak on the 9th Amendment? Deputy Rob Ward.
Yeah, thank you, sir. I can support this. There's just 3 things that I'd like to mention, and I'd like them on record, that I've mentioned them, because I might come back to. First of all, sir, any redaction process is inherently subjective, and what counts as private could vary year to year. risk any over-redaction, that weakens scrutiny, or under-redaction that compromises confidentiality. That's a really important point to make, just for the record. Second, annual presentations to the Assembly may unintentionally politicise what should remain a calm, evidence-based oversight process. And I think we need to be aware of that, and I want to voice that. And finally, early reports will be based on very small numbers, which increases the chance of misinterpretation or overreaction to isolated cases. These aren't arguments against transparency, but they are risks we should keep in view as we consider the amendment. So just to make those few points when we do yearly reports. Thank you, sir.
Thank you. Does any other member wish to speak on the 9th Amendment? Minister.
So, yeah, just like to confirm my support for the amendment.
Thank you, Minister. Does any other member wish to speak on the 9th Amendment? Deputy Balash.
So I obviously support this amendment as a member of the scrutiny panel, but there is one matter which I think I would like to draw to the attention of members, which was discussed by the panel briefly. And that is the provision in Article 74(4)(b), which requires the public report to exclude any information relating to the approved drugs. It seems to me possible that difficulties might arise in relation to the drugs which are used to administer to patients seeking an assisted death. And it would be undesirable, it seems to me, if this provision of the law were to prohibit any notion that there were difficulties in relation to the approved drugs getting into the public domain. There could be matters which require discussion. And my request is simply that the Minister should take this on board, should consider it, and see whether in due course some means can be found to ensure that anything which ought to get into the public domain, and I accept that not everything ought to, but things which ought to get into the public domain have some means of doing so and are not prohibited by this provision of the law.
Thank you. Does any other member wish to speak on the 9th Amendment? Deputy Scott.
Yes, sir. Just considering Deputy Balash's point that I think that this is very sensitive information and we don't expect many people to be using, given that the population that we are, to be using the assisted dying service. So it could actually, sometimes it could be, how can I say, I don't know how sensitive it is to actually be saying, from the family's point of view, you know, what drug was used. But I think the point that the deputy's been trying to make has been that if there turns out to be some sort of problem with a particular drug that's being administered, that something should be done about that. And I guess, yeah, he's asked the Minister a question, and I would expect that any responsible Minister of Health, if there is a drug that had some sort of problem, wasn't working or something, and I'm sure if that were the case, then there was family, there'd be one fuss about that, but that he has got that responsibility to ensure that that's put right. Thank you, sir.
Thank you, Deputy Scott. Deputy Morrell.
Thank you, sir, and I think I speak with the same concerns as Deputy Balash, and I think Deputy Scott was saying, and it is specifically around the bit about drugs being used, being excluded. For me, that makes it very difficult to support this amendment, because we know in a very different case across the cases across the Atlantic, drugs that are used to end people's lives, in this case in a non-voluntary fashion, are regularly discussed because of their efficacy, the impacts, the symptoms, etc., etc. And whilst the panel's report, quite rightly and understandably, talks about their amendment enhancing accountability and transparency, I would be really keen to understand why they've excluded the particular drugs being used from that accountability and transparency, because to me that is fundamentally important. And I don't think, and I appreciate Deputy Balash was being, I think, trying to reach out and find a common ground whereby the Health Minister could give assurances, but because we're talking long into the future, I don't think the Health Minister is in a place to give assurances because he does not know how his successors would treat the provisions of this amendment, and in my view, successors would likely treat it as written, which is to not provide information about the drugs being used. And I think it's really important to have those discussions as time goes on and technologies change and improve. And as much as that is a discussion many people might shy away from, across the Atlantic, under very different circumstances, we can see why these discussions are important. And so for me, I'm not really in a position where I can support this right now because I think the panel's made a mistake in excluding the possibility of the drugs being used being included in those reports. Thank you, sir.
Thank you, Deputy Morrell. Deputy Howell.
Thank you, sir. I'm replying on behalf of the current Health Minister, who said he would definitely be mindful to take into consideration what the last few speakers have said, sir. But it will be different, I guess, after the elections when there's a new Health Minister. Thank you.
Thank you, Deputy Howell. Deputy Wilson.
Thank you, sir. I just wanted to echo some of the concerns that Deputy Ward has around subjectivity, and I wondered if the panel chair could perhaps give some clarity as to or the rationale behind why the medical officer for health is the person who will give that particular information, recognising that there is a governance and oversight and scrutiny board that's also available to give an opinion on what information could and should be shared. I think it also raises, in terms of the way it's written at the moment, that when we're asking particular professionals to do things under this law, that we need to be mindful of their opportunity or their preference to express their conscientious objections. So I suppose what I'm looking for is to see whether this article in the way it's written actually provides for that safeguard as well. Because somebody somewhere has got to be able to produce this information, and I do think we need to make provision as to how and in what way we can get that information other than through an individual. I think it also provides an opportunity is really to improve the transparency because even when we're talking about serious incident reports that come through some of the health system at the moment, we know that those reductions are carefully considered and there are reasons for that, medical legal reasons, reasons that might actually be difficult in terms of identifying particular practitioners or particular treatments. But I think if we were to have confidence in this proposition that it was actually an appropriate safeguard, I think it raises more issues for us about whether we have actually got an objective safeguard in place here and that it won't prevent the public from having access to some of the not so nice details around what the experience of an assisted death involves. Thank you, sir.
Thank you, Deputy Wilson. Does any other member wish to speak on the 9th amendment? If no other member wishes to speak, then I call upon Deputy Doublé to reply.
Thank you, sir. I will try to answer some of the queries that have been raised. And just to remind members that this amendment would require that the annual report be presented to the States Assembly and that information would be redacted from that. Some of the speeches have focused on the drugs and the details of those substances being redacted from the report. And so I wonder if it is possible to take any part of this separately, and I don't know how finely we can do that, because from my understanding, if we voted separately on 4B1, that would actually allow people who wanted the information about the substances to be included to vote against that small part, but I don't know if that's possible. I'll wait to hear your advice on that. In terms of why we specified that the medical officer of health should be consulted, this was so that there was clinical expertise involved in the decision and in the report, because obviously when a minister presents a report to the States Assembly, that's a political act essentially, but this having the medical officer of health in there ensures that there is the clinical input into that report. In terms of oversight, I think somebody asked why a question about the oversight. In terms of clinical governance, service safety and quality, this wouldn't be the only oversight. There are, if members refer back to the draft legislation, there is an assisted dying delivery and assurance committee that would be having that ongoing monitoring and oversight. It wouldn't be just the annual report. This is a kind of gold standard, as it were, and giving the Assembly the extra oversight there. I think that I've covered everything, sir, and I apologise if I have missed anything. It's been a long day, so I hope I've covered everything. And if you could just advise, sir, on whether that part could be taken separately. If members desire that, I'm happy for parts to be taken separately, and I maintain the amendment, sir.
I think it's difficult to take Little Roman 1 separately. So our ruling is we can't.
Thank you, sir. Could I ask for the appel, please?
Thank you. The appel has been called for. I invite members to return to their seats. If all members have had the opportunity of returning to their seats, I ask the greffier to open the voting on the 8th amendment. Oh, sorry, 9th amendment. 9th amendment. All members have had the opportunity of casting their votes on the 9th amendment. I ask the greffier to close the voting. And I can report that the 9th amendment has been adopted. 41 votes pour, 3 votes contre, and no abstentions.
Those voting contre, the connotables of St Lawrence and St Brallard and Deputy Wilson.
Thank you. So we move on to the 8th amendment, which again has been lodged by the Assisted Dying Review Panel. And I ask the greffier to read the 8th amendment.
Article 76. 1. After Article 76, insert 77, review of law's implementation. The committee must, within 3 years after the rest of this law comes into force under Article 102.3, carry out and publish a review of how this law is operating. 78. Involvement of people with disabilities in law's implementation. 1. The committee must consult appropriate representatives, A, in carrying out its main function under Article 57.1, and B, in carrying out and publishing the review under Article 77. 2, in this article, appropriate representatives means persons that the committee considers to be representative of people with disabilities who are resident in Jersey. 2, renumber the subsequent articles and cross-references accordingly.
So I invite the Chair of the Review Panel, Deputy Doublé, to propose the 8th Amendment.
Thank you, sir. And I believe this is the final amendment from the panel. And once again, I thank the Minister for accepting this amendment. There are two parts to the amendment. It's a further oversight and safeguarding strengthening amendment, because we are asking that the Minister review how the law is operating and publish his findings within, or his or her findings, as it were, within the first 3 years of operation. And the second part of the law is something that our advisors raised with us, and they gave us options with this one. So they felt that disabled islanders needed to have a voice and to be listened to when any kind of review or anyone looking at how the processes of the assisted dying service was working, that it was really important that those disabled islanders were listened to and actively reached out to in a way that was accessible to them and across the diversity of people with disabilities in Jersey. And they gave us two options, and they gave us some examples from different jurisdictions of how there are standing committees where representatives of people with disabilities could be part of a standing committee that would be consulted on an ongoing basis. And the other option was to kind of embed it in some way in the review process. We did consider this and discuss it, and we decided on balance that it was better to have a requirement to consult with people with disabilities as a part of this review process. So it is a slightly lighter touch, and we think a reasonable and balanced approach. And we are grateful to the Minister for accepting this amendment also, and hope that members can support it.
Thank you. Is the 8th Amendment seconded? Does any member wish to speak on the 8th Amendment? Deputy Rob Ward.
Thank you, sir. We've got a pattern developing here. So I have to say it's been a really interesting debate, and it's been an interesting thing to, such an important debate to look at. And this is one of the amendments where I will start with my conclusion, which is at the moment I'm supportive, but there are some points I'd like to raise. And so many times around this debate, this has been a situation, I think, for so many of us. So I think there are clear potential advantages to the approach suggested by the panel. A time-bound review, and time-bound is quite important, may help identify emerging risks, barriers or unintended consequences at the early stage, allowing systems to adapt before, and that's before problems become sort of entrenched in any system, so I think that's a very good thing to do. Consultation with disability groups may improve accessibility, strengthen safeguards and ensure that operational guidance reflects the real diverse needs of islanders with physical, sensory or cognitive or mental health conditions. And they supports public confidence with the expression of openness and responsiveness. They are very good things for us to do. At the same time, sir, I considered some practical questions that perhaps the Chair can address in summing up regards the amendment. So a 3-year review period may not provide sufficient data for meaningful conclusions. I hate to be all sciencey here, but you need a certain amount of data to come to meaningful conclusions. And that depends on how quickly the service becomes established, particularly at the beginning, and numbers involved. And with small sets of data, you can extrapolate in the wrong way if you're not careful. There's a requirement to consult appropriate representatives, which is intentionally flexible. But it does raise questions to me on how those representatives are identified, how inclusive the process will be, and whether smaller organisations, and this is the key, have the capacity to participate fully. This cannot be a token gesture towards, and I'm not suggesting it is, and that's the wrong wording. I've been very careful with my wording and written down everything I was going to say on purpose. As soon as I go off of that, I say the wrong word, so let's stick to the speech. Sticks to the speech, Ward. There may also be administrative and resource implications for the committee, even if a panel is described as modest. The amendment does not prescribe the scope or methodology of the review, nor does it require government to actually act on the findings, I believe. Now, I may be wrong there, are happy to be corrected because I would like to see that in the situation. If not, it's fine, I'll just point that point out. Therefore, it must be considered how the review will be used and whether further mechanisms will be needed to ensure that any recommendations lead to improvement in practice. Because this is, if you like, sir, the ultimate practice that has to be got right. It is well, we all know why. In summary, this amendment introduces structured review and disability-inclusive consultation into the assisted dying framework. It's great. It offers potential benefits in terms of transparency and safeguarding. Excellent. While also raising questions about timing, implementation, and the practicalities of engagement. Those are the issues I think we really need to think about carefully. But as I say, so at the moment, I am supportive of this, but I think the points I've raised need to be considered, and I'm pleased to put them on the record so that they are there, perhaps for future reference, who knows. Thank you, sir.
Thank you, Deputy Rob Ward. Does any other member wish to speak on the 8th Amendment? Deputy Mezek.
Thank you, sir. I also completely support this amendment and thank the Chair and the panel for bringing it. I wanted to highlight one potential outcome that could come as a result of this that is why the amendment is important, because if we agree to set it in stone that 3 years after the law comes into force that there will be a review on how it's operating, we're opening ourselves up to the possibility that there may well be a review of it that concludes we're not doing so well at it, and that being a possibility has to be something that drives us forward to make sure that this law and the service that will arise as a result of it is a success and does everything that we want it to, whilst genuinely meeting all of those safeguards that we consider so important in all of this. And the reason I thought it was worth standing up to make that point, sir, is because we have from time to time seen the stories that get published about things that are happening in the health service. There's one today about people waiting very, very long times to get operations. And those are things that affect people's quality of life and can lead people to make decisions and evaluate how it is they want to live their lives from that point. And it highlights how vital it is that everything outside of the assisted dying service must be delivered as well as possible for our population, and that there is still a huge amount of work that's got to be done to make sure that our health service meets the needs of all islanders. And if we aren't able to improve it or things slip backwards, that can have unintended consequences. And setting this requirement that we will be reviewing this law after 3 years, I think acts as one extra incentive to make sure that we're not just focusing on the assisted dying service and making that a success, but it's our health service as a whole that has to be a big part of that. And how embarrassing it would be for us if we were to be one of those jurisdictions that takes the brave step in introducing an assisted dying service, and us in that moment feeling really proud of ourselves for being so progressive, if a few years down the line we end up being the first to be told actually you haven't done it so well. And that is always a risk if we don't keep our eye on the ball and make sure that we do make it a success. And that's why I wanted to speak to say I think this amendment is particularly important, and I hope the Assembly accepts it.
Thank you, Deputy. Does any other member wish to speak on the 8th Amendment? Minister.
I fully support this amendment. In doing so, I'd like to assure members of the public that if the Assisted Dying Review Panel or Committee were to identify any issues before the end of the 3-year period, the matter would be brought before this Assembly immediately, and we certainly wouldn't wait if further action was required. And I'd also like to endorse the requirement for the committee to consult people with disabilities as part of the 3-year review process. And I urge members to support this. Thank you.
Thank you, Minister. Any other member wish to speak on the 8th Amendment? If no other member wishes to speak, then I call upon Deputy Dubé to reply.
Thank you, sir. And I wholeheartedly agree with Deputy Mezek's assertion that this is one of the more important amendments. I feel that as well. And We did consult with many organisations, and I'm really grateful actually for the range of charities, first of all, that we have in Jersey that advocate for people with disabilities. Enable Jersey, Autism Jersey, ADHD Jersey, Liberate Jersey, ICANN, All Matters. There are more, sir, but we are very lucky actually that we have many very effective charities, and several of these organisations actually submitted evidence to the review panel. So our review overall has very much been informed by views of islanders with disabilities, and we actively sought to do that by requesting those submissions. So the question was raised about, is 3 years long enough? And actually, I mean, how long is a piece of string? Because actually we initially were proposing 1 year, and then we had that thought about actually that's not long enough. I think it was the minister's officers that raised that with us. So we did consider that, and we extended it to 3 years. But it shouldn't stop there. Actually, you know, there can be a further review beyond that, and there probably should be, perhaps every 2 or 3 years. And I'm sure that future assemblies will consider that. And in terms of making sure that this consultation and the interaction with islanders with disabilities is meaningful, again, I wholeheartedly agree. And actually, this is one of the reasons why throughout the review, so it's not just this amendment, although this amendment might be one of the only places where you might see the word disabilities. Actually, Sarah, on reflection, when I looked back through the review, it's actually something that is embedded throughout our entire review, awareness of islanders with disabilities. It's embedded in our requests for data collection on personal characteristics, for training on coercion and vulnerabilities there, and other areas of training in the public awareness recommendations. So I feel that the panel's recommendations and amendments are very thorough and meaningful in regards to islanders with disabilities. And essentially, when it comes to that review being published and the findings of those conversations with islanders with disabilities, the accountability actually lies with, it's the Assembly to provide that political accountability. So that's all of us. It's down to all of us to ask those questions that Deputy Ward has raised about, was this consultation meaningful, and to keep a watchful eye on that. And we should be doing that actually a lot more, I think, and advocating a lot better for islanders with disabilities and trying to ask those questions in more context. So I agree with those questions. I think we need to keep asking them. And I think that this amendment will go some way towards improving the making sure the views of disabled islanders are listened to and prioritised. So I maintain the amendments and ask for the appel.
Thank you, Deputy. The appel has been called for. So I ask members to return to their seats. If all members have had the opportunity of returning to their seats, then I ask the greffier to open the voting. All members have had the opportunity of casting their votes on the 8th Amendment. I ask the greffier to close the voting. And I can report that the 8th Amendment has been adopted. 47 votes pour, 1 vote contre, and no abstentions. So we move on to Section H of the Second Amendment that was lodged by the Minister for Health and Social Services. And I ask the greffier to read Section H of the Second Amendment.
Article 85. In Article 85(1)(a), after "if they are suspended," insert brackets, "even if on an interim basis," close brackets.
Thank you. I invite the Minister to propose Section H of the Second Amendment.
Sir, the General Medical Council has queried whether the reference to a professional being suspended in Article 85 of the draft law includes interim suspensions in addition to substantive suspensions. An interim suspension may be required where, for example, an investigation is required following a complaint. And this part of my amendment clarifies that when a professional is suspended by a professional registration body, whether on an interim or substantive basis, they will be suspended from the assisted dying register accordingly, either on an interim or a substantive basis. So I think this is reasonably clear, and I hope members see fit to support it. Thank you.
Thank you, Minister. Is Section H of the Second Amendment seconded? Yes. Does any member wish to speak on Section H of the Second Amendment? If no member wishes to speak on Section H, then those members in favour of the appel has been called for. If all members, I invite all members to return to their seats. If all members have had the opportunity of returning to their seats, I ask the greffier to open the voting. All members have had the opportunity of casting their votes. Then I ask the greffier to close the voting. And Section H of the Second Amendment has been adopted. 46 votes pour, 1 vote contre, and no abstentions. Then we move to Section I of the Second Amendment. And I ask the greffier to read Section I of the Second Amendment.
Schedule 3. 1. In Schedule 3, before paragraph 1, insert 1. Capacity and Self-Determination, Jersey Law, 2016, amended. 1. This paragraph amends the Capacity and Self-Determination, Jersey Law, 2016. 2. After Article 11.4, there is inserted 4A. An LPA cannot confer authority for any decision or matter that affects an individual's assisted dying process under the Assisted Dying Jersey Law 2000. 3. After Article 24.9, there is inserted 10. The court cannot exercise a power under this article to affect an individual's assisted dying process under the Assisted Dying Jersey Law 2000.
Thank you. I invite the Minister for Health and Social Services to propose Section I of the Second Amendment.
So it's always been a clear point of principle that decisions made under the assisted dying law can only be made by the individual. The draft law, as lodged, doesn't allow for best interest decisions to be made on behalf of an individual who doesn't have capacity. For example, and quite understandably, no person can decide that it's in another person's best interest to have an assisted death. This part of my amendment further clarifies this position by amending the Capacity and Self-Determination Law to state that neither a person with lasting powers of attorney nor a court-appointed delegate may make an assisted dying decision on behalf of an individual. This aligns with the principles of personal autonomy and choice agreed in P.18 2024. So it's a very straightforward amendment, and I hope members see fit to support it. Thank you.
Thank you, Minister. Is Section I seconded? Does any member wish to speak on Section I? Deputy Coles.
Thank you, sir. I just thought I should advise, because I misread this to begin with as I was reading the amendment pack about what it did for the lasting power of attorney. As somebody who holds a lasting power of attorney for someone purely for financial matters, thankfully, I can express to a lot of people the difficulty it is sometimes of getting elderly parents or relatives to agree that they need some help and support. And if this wasn't included, it would leave a very big gap, because the principles of having a lasting power of attorney is it's always supposed to be in that person's best interest and not the person who holds that power of attorney. So this is a very sensible addition, and I'm glad it got caught before we approved this law.
Thank you, Deputy Coles. Does any other member wish to speak on Section I? If no other member wishes to speak, then I close the debate. I call upon the Minister to reply.
So nothing further to add.
Then I ask all members in favour of the appel's being called. I ask all members to return to their seats. If all members have had the opportunity of returning to their seats, then I ask the greffier to open the voting on section I of the Second Amendment. If all members have had the opportunity of casting their votes, then I ask the greffier to close the voting. I can report that section I of the Second Amendment has been adopted. 45 votes for, 1 vote contra, and no abstentions. Very well, so that concludes the amendments to the articles. So we return to consider the articles as amended by the 17 amendments. Does any member wish to speak on the articles as amended? Deputy Dubley.
Thank you, sir. I'm not going to speak for very long. I can see it's nearly the end of the day, and I have covered much of the content of the panel's report when we have been speaking about the amendments, and I've tried to refer to recommendations where I can, but I just wanted to draw out a couple of areas. One of the strong themes running throughout the panel's work has been the requirement that we feel for strong palliative and end-of-life care to be in place in Jersey. And I just wanted to raise that again at this moment as an enduring principle that should be continued in the implementation phase if this legislation is approved today. It's critically important. There should always be a real, actual, meaningful choice for islanders, and no one should ever choose assisted dying because of a lack of appropriate care. And I believe that the Minister agrees with me on that and with the panel on that. We've talked quite a lot about administration routes and the waiver and coercion. I'm not going to repeat any of that, sir, but what I did want to draw members' attention to was some of the sections of our report that talk about the funding and the implementation. We did have just one submission on this, actually, for which we were very grateful because it was a very well-informed and detailed submission. But we do have some small concerns about the fact that there is an indicative kind of envelope of funding for this, but not really detailed, not really enough detail at this point. I do have some confidence in the Minister that this will be forthcoming in the implementation phase, and I think it's really important that clear costings, information about contingencies, and regular review of the finances associated with the assisted dying service, and indeed the governance arrangements for those finances, that is deeply embedded in the service as it is stood up, if this is required today. Training and guidance, again, and this is understandable because you wouldn't produce training and guidance in a huge amount of detail for a law that hasn't been approved yet. So the panel does understand this, but we weren't able to see the detail of training and guidance at this time, which is why we made some amendments. But we would like to reiterate that as that content still needs to be built, we want to see that the training is rigorous, multidisciplinary, and that it is ready well before the implementation of the service, so that that guidance can be read and understood and the training can be digested and put into practice immediately as the service is stood up. Again, I wanted to briefly touch on public awareness. We have many recommendations about that, and just to reiterate the fact that it must be accessible and inclusive, and there must be clarity about what is allowed and what is not allowed. And I'm sure that the Minister will put his mind to that as well. in this next phase if the law is adopted. And so members will be aware, so taking my scrutiny hat off, members are very, very well aware at this point of my humanist beliefs, and the aside from the work that I have done on scrutiny, for which I took my humanist hat off to do the scrutiny work, but I put it back on now to express my own personal views about this legislation, which I hope is approved today. And so I think it's one of the most meaningful and important things that we can do for our island. And death is never an easy thing, but it's something that everybody will face at one point. And I think that, as I said in my previous speech on the principles, if we can approve this legislation today, which I believe has extremely rigorous and robust safeguards and principles underpinning it, for which I think that we can be really proud of as an assembly. If we can approve that today, after all of the work and the consideration and the speeches and the thought that has gone into this from across the assembly, I think we can be really proud of this. And I think that it is a gift that we are giving our population, it's a compassionate gift. And as a humanist, I'm guided by principles of compassion, and I feel it's really important that we can approve this assisted dying legislation as a gift to our population that will make some really difficult moments in people's lives a little bit less painful. And I hope that we have the courage and the confidence in our own work to do that today. And I thank the Minister for the work that he's put into this, and his officers. There's a huge level of expertise behind the scenes for which the panel have been really grateful to be able to interact with. And also our own officers, I think, I'm not sure people realise actually the amount of work that goes in behind the scenes with scrutiny reports. And I was talking to one of the other panel chairs recently, and we were reflecting upon the fact that actually the kind of academic nature of this work, it's almost like writing a dissertation, isn't it, when you write a scrutiny report? And I have seen over the years the standards of scrutiny reports just going up and up and up and up. And I'm just so grateful to the GRAF and the scrutiny officers for that foundation that they can give us. It really, really enhances the work that we do in this assembly, and it helps us to create really excellent quality legislation like this, and the scrutiny process continues to grow, I think, and to be ever more meaningful and constructive. My panel members, again, we have managed to be respectful and compassionate with each other, because there were some really difficult conversations around the subject matter at times, and I am so grateful and feel quite honoured actually to have been part of such a panel with, again, the level of intelligence and thought that was given to this. I'm very honoured to have led that panel. And also our advisors, just to give one final thanks to the advisors and to everyone who submitted evidence to the review. I am proud of this review, and I hope that members feel it has been constructive and it has added to the considerations of this legislation. I will be supporting the legislation today, and I feel proud if we can support this across the Assembly.
Does any other member wish to speak on the articles as amended? Deputy Moore.
Thank you, sir. A clear message has been sent to members of the Assembly who voted against the principles in 2024. That message was those principles have been adopted, time to get out of the way and let us just get on with this. But sir, in 2024, I spoke about my pragmatic rather than moral concern about this about this proposal. And sir, my concerns are greater today than they were in 2024. To put it very simply, sir, we have had 2 budget debates since that debate in 2024. And sadly, sir, the current health minister has demonstrated no ability whatsoever to get his finances under control and to assure us that the health service is being well run and the budget is well managed. Yet this proposal, sir, proposes a new service to be added to those that are already offered to the members of our community at a greater cost. So that is a cost that we do not afford currently, and particularly as a small jurisdiction, this is highly technical, new legislation, a new area for us to step into, and I certainly do not think that we are well enough prepared to be at that forefront of such legislation. And so for those pragmatic reasons, I will once again be voting contra today.
Thank you. Deputy Miles.
Thank you, sir. I chose not to speak during the debate on the principles, although I did speak earlier, and I indeed haven't spoken on any of the amendments today. So what I want to do at this point is to reflect at this final stage on the journey that we have taken to reach this point, and I think I'm more tended to align my views with Deputy Doublé and her panel. For me, sir, the right to an assisted death has never been merely a legal construct or a clinical mechanism. It's always been a profoundly human question, and one that reaches into the core of our values. As a community, our compassion, our understanding of autonomy, and our respect for the dignity at the end of life. And this was always going to be a difficult debate, and we've heard from every single member of the Assembly about personal experiences of terminal illness, of sitting at bedsides, of watching gradual decline, or witnessing what might be described as a peaceful death, or in other cases a deeply distressing and prolonged one. And those experiences inevitably shape our responses, and they shape our doubts, and they shape our convictions. And it's for that reason that I really wanted to speak and put on record what my own views are about this area. And in early 2020, the Minister for Health and the then Minister for Health and Social Services committed to commissioning a citizens' jury following sustained community interest in assisted dying at local level. And I was privileged to serve on the independent advisory panel with responsibility to advise, to check, and to challenge throughout the process. And having overseen the design of the jury and observed the delivery of its sessions, I remain confident that it was appropriate, balanced, and robust. So for me, at the heart of my position lies a single principle, that of autonomy. And we heard from both the Dean and Deputy Balash yesterday about autonomy. Autonomy is not an abstract philosophy. It is the recognition that competent adults have the capacity and the moral agency to make informed decisions about their own lives. And in the context of terminal illness, autonomy includes decisions about the manner and the timing of that death. So for me, sir, respecting autonomy means acknowledging that an adult with capacity who is intolerably suffering from an incurable physical condition and who has a clear, voluntary and settled wish to die should have the option, within a tightly regulated framework, of an assisted death. The ability to die with dignity in a manner of one's own choosing is, in my view, a fundamental human right. And I take the view of Deputy Miller that the human rights law was never intended to adjudicate upon assisted death. But that position has been reflected in European jurisprudence, including the case of Deborah Purdy, which clarified the importance of legal certainty and personal autonomy in end-of-life decisions. Until this draft law, in Jersey, that autonomy was never evenly distributed. Those with sufficient financial means could travel to Switzerland, and they often did so alone, fearing potential criminal consequences for loved ones who accompanied them. Many felt compelled to travel earlier than they would have wished, while still physically capable of making this journey and self-administering medication. For those unable to travel because of cost, health, or circumstance, there was no equivalent lawful option in Jersey. And that was an inequality based on wealth and physical capacity. And I don't believe that to be just. And today, sir, this Assembly has addressed that disparity, or I hope will address that disparity by adopting the draft law. The principles of justice demand that we treat individuals fairly and consistently, and we've all long recognised that competent patients may refuse life-sustaining treatment, an issue that Deputy Luce mentioned yesterday. We accept that individuals may decline interventions that would prolong life, yet we have denied a small group of terminally ill individuals the option of bringing unbearable suffering to a peaceful end under medical supervision. Palliative care in Jersey is compassionate and of a high quality, and I continue to support the strengthening it further and embedding gold standard provision within our wider safeguarding framework. But we must acknowledge an uncomfortable truth. Palliative care has limits. While advances in medicine have alleviated much suffering, they cannot alleviate all of it. Distress, whether physical, psychological, or existential, may become intolerable. Compassion is the cornerstone of medical ethics, and that is something that has been pointed out by the review panel. Compassion doesn't require us to prolong suffering at all costs. It requires us to respond to suffering with humanity. And this draft law does not replace palliative care. It doesn't eliminate it. It doesn't diminish it. It operates alongside it as a final safeguarded option for a very small and clearly defined group of people. Concerns about safeguarding have been central through the main debate, and quite rightly so. The risk of coercion, of vulnerability, of incremental expansion, these are not trivial concerns. They have required rigorous examination. We've debated eligibility criteria in detail, and we've considered residency requirements, waiting periods, mental capacity assessments, independent medical evaluations, documentation, reporting, and oversight mechanisms. In jurisdictions where assisted dying is legal, strict procedures are in place. And evidence from those jurisdictions doesn't demonstrate the widespread abuse that some feared. In my assessment, the law we have adopted, or we are likely to adopt, reflects these lessons. It is thorough, it is measured, and it is responsibly drafted. And importantly, it also preserves the freedom of conscience for healthcare professionals who choose not to participate. One of the most sincerely held objections to assisted dying rests on the sanctity of life, the belief that life is inherently valuable and must be preserved regardless of circumstance. And I agree, life indeed is so very precious. But reverence for life must also include respect for lived experience. Forcing an individual to endure prolonged and intolerable suffering against their settled and competent wishes may itself undermine dignity. As members know, I do not share the theological view that the timing and manner of death must be determined by divine authority. Others in this assembly do hold that belief, and I totally respect their sincerity and the integrity with which they have argued their case. But we legislate for a plural society, and within that plural society, competent adults must be permitted to make deeply personal decisions about their own lives, provided that robust safeguards protect others. I've been thinking today and yesterday of a Jerseyman, Alain Duchemin, who came and addressed the citizens' jury in April 2021. He was terminally ill, and he asked, "What makes anybody think that they have the right to force me to die in a particular way that I don't want?" And that question has echoed throughout this process, and today the Assembly is going to answer it. I too have personal stories about loved ones who have died in distressing circumstances. Sometimes it was a good death, others it was not at all what the person would have wanted for themselves. I hold very clear views about how I would wish my own death to be managed, and those views are well known to my family, and not all my family agree with them. And that is why, precisely why, autonomy matters. So this draft law doesn't compel anyone to choose assisted dying. It doesn't diminish the rights of those whose beliefs prohibit it. It creates an option, carefully regulated, clinically overseen, and ethically scrutinised for those who meet the strictest criteria and who make a voluntary and settled decision. Sir, this debate has spanned years. It's involved public consultation, a citizens' jury, ministerial working groups, detailed scrutiny, amendment, and sustained ethical reflection. Above all, sir, it's required courage from those who shared their stories publicly, from colleagues who spoke about deeply held beliefs, and from this assembly in grappling with complexity rather than simply avoiding it. And the measure of today's decision will not lie in the vote count, it will lie in the implementation, in the rigour of training, in the vigilance of safeguarding, in the transparency of oversight, and in the continued strengthening of palliative care. And my support for this proposition has always rested on three foundations: compassion, respect for autonomy, and recognition of the limits of medicine. I've said in the previous debates that I will only support this law if I'm satisfied that robust safeguards in place. I am satisfied that freedom of conscience is protected, and I believe this Assembly has acted thoughtfully and responsibly. Today, sir, we have the opportunity to enhance dignity at the end of life for the small number of people who will face the most difficult circumstances. That decision was not taken lightly, but it is one that I'm content to stand by, and I shall be supporting the draft law as amended. Thank you, sir.
Thank you, Deputy Miles. The next member I have down to speak is Deputy Howell, followed by the Constable of St Martin.
Thank you, sir. And I thank the Health Minister and the officers and the scrutiny panel and everyone who has worked incredibly hard, and for the many, many hours of debate we've had on this subject. But I would like to ask that before any implementation takes part, that the Health Minister comes back and lets us all know how this will actually work in practice. I am not a supporter, sir, for religious reasons of assisted dying in this island, and I just would like to have that on record. I respect that I'm in the minority, but I just would like to say that. Thank you, sir.
Thank you, Deputy Howell. The Constable of St Martin.
Thank you, sir. I have not spoken during this debate, but I've spoken in the previous assisted dying debates, and I just wanted to put on record to thank Deputy Doublé and the assisted dying panel for their excellent scrutiny, and thank the Health Minister and his assistant ministers and all who've contributed to this draft law in any way, shape or form. I'm extremely proud of our Assembly today. This has been an outstanding, respectful and intelligent debate. I will be voting for. I believe that this draft law has appropriate, robust safeguarding and oversight and is respectful and compassionate. Thank you, sir.
Thank you, Constable. Next is the Constable of St Saviour.
Thank you, sir. This draft law, sir, has troubled me immensely. I don't believe that we should sentence someone to death, and I also conversely don't believe we should sentence somebody to life if that is not their will. I was going to support this, sir, but I was very disappointed we did not get the First Amendment through by Deputy B. Waters and Clement, which was the waiver. I would like that just to be completely reinforced, the ability to change one's mind. I would just like that reinforcement. And also, I didn't want relatives and family members criminalised or penalised if they tried to persuade their loved one or offspring not to take the medicine, which I understand is not pain-free. It actually burns and is not a pleasant end. But I stand to be corrected on that one. I regret that for those reasons, I cannot support the assisted dying law. Thank you, sir.
Thank you, Constable. Deputy Morrell.
Thank you, sir. I know this State Assembly is very aware of my lack of support for the law in front of us, but I actually stand to first of all, I thank the scrutiny panel for their work, not just this scrutiny panel, but previous scrutiny panels as well, and the citizens' jury. and all those who have taken part in this. My initial reaction when this came up in 2018 as an election issue, so it's been running for my entire time, this issue of assisted dying has been running in the entire time that I've been a States member, was the importance of scrutiny, because, again, my rejection of the law stands upon the practical implementation and the fact that I still just don't believe that this Jersey should be leading the way in this, in terms of the British Isles. But, you know, I also deeply respect the views of the States Assembly and the States Assembly wanting to take this forward. But my reaction back in 2018, and then that consolidated with an amendment in 2021 to ensure greater scrutiny of this than would ordinarily be the case for other legislation that passes through this Assembly. And I am very assured by this scrutiny panel and previous scrutiny panels, the work of the citizens' jury and others, that scrutiny has taken place. And I'm really pleased and I'm grateful to them for doing that work on the island's behalf. And, you know, and that's the principal reason why I stand. But similarly, I also want to stand to, is congratulate the right word? I think it may be the health minister, in the same way that I did with Deputy Mezek with his rental tenancy law. I know that this particular legislation was, you know, one of the burning reasons that the deputy stood for election in the first place. And I, you know, when I see, even if I disagree with the law, when I see one of us working really hard to get something through the Assembly that they truly believe in, and getting that support and doing the work to get that support, it is an impressive thing to see. And I am really pleased on his behalf that he can leave, regardless of what happens in elections, he will have achieved one of the main reasons that he entered the Assembly. And that is something I take my hat off to him for that, sir. And I'm pleased that other members will be able to support this law, because I, as I said, won't be able to. Finishing up, sir, it would be wrong of me and remiss of me to not make a cheap political point somewhere, sir, and that is on our behalf. We are, as the state, often attacked for not changing things. And, you know, I know in all the work that we do that is an unfair attack. But this law, more than any other that I've seen in my 8 years in this Assembly, really does prove to those naysayers that we do change things in this Assembly. I may not agree with this change, but that is irrelevant. This Assembly does change things, and it frustrates me time and time again to hear those people outside telling us that we don't, nothing ever changes, nothing ever changes. I've seen so much change in the 8 years that I've been in this Assembly, and this is probably the largest of all the changes, because this is obviously goes down to, you know, millennia of belief that life is sacred, and that, as Deputy Miles said, that only a divine being has the right to take our life. You know, that has been the kind of accepted view for millennia, and we're very likely to change that very, very shortly. And so this is probably the biggest change I've seen in my 8 years, but it's one of many, many, many changes that this Assembly has done during those 8 years. And on all of our behalf, I'd just like to point that out to those people out there who say nothing changes. So I won't be supporting this in the final 2 readings, but I do understand why it's very likely to go through. Thank you.
Thank you, Deputy Morrell. Deputy Renouf.
So, I think are we in third reading now? Can I just
No, second.
In that case, I will sit down and defer.
Does any member, Deputy Scott?
Sir, I wasn't going to speak, but I have witnessed an assisted death. And maybe others too. Maybe some people saw the death that was broadcast in a documentary. A couple shared a very private moment where an individual with motor neuro disease chose to go to Dignitas to take his life, and his wife was present. And I have heard, and I believe that this States Assembly has had a very involved discussion, and much of the outcomes during the course of debate have confirmed what has been some incredible considered work on the part of policy officers and the scrutiny panel. And the reason why I mentioned this death at Dignitas was that the individual who died was he actually seemed quite a robust man. He had a character man, his wife was there, he was talking, but he had to choose that moment to die because the actual rules in that jurisdiction was that he had to have capacity at that time. And his fear was that he would deteriorate at a point where he could not do this, make that decision anymore. So in front of his wife and in front of the viewers, this man who looked relatively able to talk, converse, all these things, took a substance and died in front of us, the viewer, his wife. And I mean, she was there, I suppose, in a sense. It was an assurance, safeguard that nothing was untoward. This was indeed his choice. And I believe that what we have resulted in is actually something a little bit more humane. Deputy Balash said that if we needed a law that was appropriate for Jersey, and there has been reference to public consultations where people have expressed views and what they thought was right. And I believe that what I saw on that documentary actually was assisted suicide, whereas by virtue of not of having the waiver, of actually enabling people to say, right, I really am getting so close to this point where I believe that that of no return, but so I'm deciding this date and that's it, I will go then. That actually we have got towards a step where perhaps it can be better for the family, where people can go closer to that path of no return anyway. I very much appreciate that the views of some people who, for religious reasons, feel like life is a gift and that why interfere with what God intended you to, where you intend to be. But then you might well say, I suppose, we've interfered with that with the development of drugs and all these things. That's been given to us too. So, sir, finally, I was happy that that final safeguard, the one that apparently no other jurisdiction has adopted, this one where there is that right of appeal if there is some concern that a legal procedure has not been followed or it's been irrational, has been put in there. We actually have a law with more safeguards than many, and I therefore will be supporting this law with that confidence. Thank you, sir.
Thank you, Deputy Scott. The next speaker is Deputy Jeune, who's online. Deputy Jeune.
Thank you, sir. Thank you, sir. I would like to first thank the Minister and his officers and, of course, the scrutiny panel for guiding us through this draft law, its contents of the articles and what they mean, and the amendments that were put forward today, whether they were passed or not, so that we could have a very good debate of the last few days and have come to where we are now in looking at this law as a whole. I've supported the move to see assisted dying be introduced in Jersey since I first entered this assembly, not as long as Deputy Morel, but still it has dominated even when we were doing our hustings in 2022. But I've always supported it because I believe in self-determination, and we should have autonomy over our bodies, our own lives, and ultimately the manner of our death. We already recognise this principle in other laws. The central question always, for me, has been whether we trust competent adults to make profoundly personal decisions. And I think consistency matters here. Autonomy cannot be something we defend only when it's politically comfortable. But autonomy must sit alongside safeguarding. That balance has shaped this legislation from the beginning. That is something that I have constantly also been been asking for in the different discussions that we've had on this law. But I think the passing of this assisted dying law, and I believe it will show that Jersey is capable of dealing with complex ethical issues in a measured and mature way. And I think this is important, that we've taken time to consult, to scrutinise, to amend and to debate properly. This hasn't been rushed. It has followed years of public engagement, citizens' panels and detailed scrutiny work, and that matters. And I think I want to echo what Deputy Morrell says, that this is important, that it's taken its time, that we've taken our time to listen, to understand, to really get to grips with the detail, so that we all are confident when we go to the final vote soon, what we know in front of us. And I think that's really important for the wider public to understand that sometimes we may be moving slowly, but we're moving slowly because it's really big, important issues and ethical issues that we are dealing with. And there is the need for this engagement, for this scrutiny, for there to be amendments of this detail that we've had the last few days. Is at the heart of this is a law that is compassionate and dignity, having dignity at the end of life. And it provides that choice under strict safeguards for mentally competent, terminally ill adults who are facing unbearable suffering to make a choice. And for many people, the reassurance is not that they will use it, but they will not be forced to endure suffering against their wishes. However, the passing the law is not the end of our responsibility, and I want to highlight this. And we had this points raised earlier around one of the amendments we had earlier, but I think it's really important that we raise this again in the final discussions, that implementation will require vigilance. And as legislators, we must continue to monitor how this law operates in practice. We must ensure to scrutinise the data, to ask the difficult questions, and to have those difficult questions accepted, that they are difficult questions on purpose to be asked, not for any political gain, but also to understand that about what the implementation really means, and have that open dialogue with clinicians, families, advocacy groups, and those directly involved in the delivery. And we must listen, especially if concerns arise. And I think that is our ongoing duty and the duty of the next states' assemblies to come, that we listen. Safeguarding is absolutely critical. The eligibility criteria, independent medical assessments, waiting periods, review mechanisms are there for a reason. It is not unrestricted measure. It's carefully constructed and designed to minimise risk while respecting autonomy. But safeguarding also means ensuring that assisted dying is never a substitute for proper care, and a genuine choice only exists if high quality palliative care is available to all who need it. And that is why placing a statutory duty on the Minister for Health to provide palliative care was so important, something that I really thought was very important to have in parallel when we brought forward this law, to have that statutory duty, because it requires funding, workforce planning and long-term commitment to provide important palliative care. So this has not been an easy set of debates, and nor should it have been. The seriousness of the subject demands seriousness from all of us, and members have spoken from personal experience, from faith, from professional expertise and from deeply held values. But today's decision reflects something important, that this Assembly can approach difficult issues with care, evidence and courage. And for me, supporting this law has always been about trust. Trust in individuals, trust in safeguards and trust in this Assembly to legislate responsibly. And now we need to implement this with the same seriousness and humanity that brought us here. So I will be supporting this law. And again, I would like to thank the Minister, his officers and Scrutiny and their officers for all the work they've done to help us get to this point with such an important matter. Thank you.
Thank you, Deputy Jeune. We've reached the point in standing orders where I'm required to remind members of the possibility of adjourning for the evening adjournment.
May I ask if there are any members waiting to speak?
No other members have indicated that they wish to speak. Obviously, there's the Minister's reply. Deputy Gorst has indicated he wishes to speak. Perhaps it'd be helpful if any other... We'll have the adjournment. Very well. We will adjourn. The states stand adjourned until 9:30 tomorrow morning.